From supplementary list for final disposal item 1. Second up is 309 of 2016.
Sorry?
Very short pass. Mr. Jharkhand will catch one.
Just a moment. Where is your written submissions? Where is your written submissions? इसी में adjournment मांगे थे क्या? You have not filed it.
We haven't filed.
Sorry?
We haven't filed.
Why have you not filed it? You are not interested? Then?
It's our fault.
आपका जो एक और केस है ना उसमें पास ओवर नहीं करेंगे सो यू स्टार्ट योर आर्ग्यूमेंट
Item 2. First appeal 118 of 2023.
FA number 118 of 23. Nobody appears on behalf of the appellant. In spite of order dated 5/5/2025, no synopsis of argument has been filed. In order to give one more chance to the petitioner नियोग appellant. Post on 15th of July.
Item 3. First appeal 298 of 2023.
FA number 298 of 2023. As per office note, the corrected copy of the judgment and the award has been received. Consequently, IA number 4338 of 25 which was filed for sending the judgment and decree to the court concerned for necessary correction is closed. Since appellant is absent, in order to give one more chance, लेकिन तो record आया क्या इसमें?
What I was.
आया हुआ है. Formally admit तो हो चुका है, as I understand.
Okay.
15th.
Item 4. First appeal 15 of 2025.
You start your argument, don't break.
I'm not seeking password.
Not required.
The client,
Start.
the client has taken back the
Very
even
good.
NOC.
You have given NOC.
This is very unclear, Lordship.
We'll appoint an amicus. You see, we will just record and dismiss the case. He has taken NOC from you. Nobody is there to assist this court today. I will dismiss the case. Let him file a restoration.
Let it be password for few cases.
You file a restoration application. He has taken the file. What is the purpose of
Let it be
password?
password for few cases. If I will just consult the client because he has taken the NOC.
He has taken the NOC. Nobody has entered appearance. Therefore, this case has to be dismissed.
Let
For
it be-
non-prosecution, we
let
will
it be-
restore it.
Let it be password.
There he comes. You are there?
Ladyship, yesterday I received the wakalat.
Very good. You start reading the impugned judgment.
Ladyship, I have been instructed.
We'll read it together. We'll read it together. Don't worry about it.
I will file
It's a first appeal. We have to read it.
I have been instructed to engage a senior advocate. Ladyship.
Very good.
Yesterday I have received the wakalat.
I will not adjourn it. You start reading the file. We will commence the proceeding today. Let us see what are the contours of the case, what are the evidences. You place it before us. And then for the final arguments, you can have a senior counsel. There is no problem about it.
Ladyship,
This file I have read. You see, yesterday I was not well. I could not come. Right? And it was informed to the counsel for the other side, maybe you also, that it will be listed today. Right? I have spent 3 hours reading this file, and if you seek adjournment, I will impose a cost of 1 lakh rupees, not a penny less than that.
Ladyship, in that case,
Who is your senior?
Ladyship, I have been instructed to engage Mr. Senior Advocate. Mr.
No problem. Call him please.
Ladyship, then
You start
I
reading
may
the
apply for
impugned
password.
judgment.
Ladyship.
Half an hour. You have to, you see, whosoever comes. The basic thing in first appeal is the plaint and the written statement, the contours of the case between the parties, and then if your senior still wants to argue the case on merits, then we can just give one more date. There is no problem about it. But one thing is very important in this case, that the date, time, place, and witnesses of the gift deed does not find place in the records. So we will see the records and find out if it is available.
Ladyship, I was unaware the matter will be listed today. And
You were unaware?
Because
When
I
you-
have been handed over the wakalatnama yesterday.
Very good.
So I was not.
If your client wants to play hide and seek, we know how to play. You have not filed wakalatnama so far?
No, Your Ladyship.
Okay. I'll dismiss the case, you file your restoration. I'll dismiss the case, you file your restoration. You have no locus, so I'll record your absence. I'll pass it over for half an hour. You get your wakalatnama ready, correct? And if you want to file it, it's okay. And you can start reading the impugned judgment. And if you don't want to do that, we'll dismiss the case for non-prosecution. Restoration will be a huge problem for you. There are so many parties, and with lot of effort they have had. Notices will be issued. A few would die in the meantime. This is what is happening to civil litigation. Come in half an hour. Wait for some.
It's a very unusual thing. Here.
We know how to handle unusual things. क्या हुआ आपका?
What we see in the High Court that once the wakalatnama is on record, he won't be discharged
Certainly.
unless a fresh one is filed.
Certainly.
So our earlier counsel has a duty to
Till it
argue
is
the
filed.
case.
Till it is
He has
till
to
it is
argue
filed.
because that is on record. That is on record.
Certainly. Order already हो चुका है. चलिए next call. अगला डेट में नहीं आइएगा तो डिसमिस कर देंगे. आ तो गए हैं डेट से. कुछ एडवर्स ऑर्डर नहीं किए. नॉन अपीयरेंस कैसे काट देंगे? Under what provision of law? If I delete your non-appearance, then the adjournment will be at my instance. Correct? क्या होगा? Nothing is going to happen. 14 जुलाई को रखे हैं, 15 जुलाई को रखे हैं. उस दिन आइएगा कर लीजिए. आप सिनॉप्सिस भी कहाँ फाइल किए हैं? रेडी कैसे हैं आप? लेके आए हैं तो फाइल कर दीजिए. हम पढ़ के आएंगे ना. हमको पढ़ना पड़ता है. आप लोग मत भी पढ़िए तो भी कोई बात नहीं. अदर साइड को सर्व कर दीजिए. तो आपने भी नहीं फाइल किया सिनॉप्सिस? कहाँ किया है?
synopsis, written arguments, and judgments subjoined.
फाइल है उनको तो नहीं दिखा रिकॉर्ड में, कब फाइल की?
कल
कल फाइल की है ना, तो कहाँ से आएगा मेरे पास?
last date was yesterday. Last date as per your regulation photo was yesterday. So we filed it yesterday and was
मेरे पास नहीं आया है, मुझे पढ़ना तो पड़ता है ना, मेरे तक नहीं पहुँचा। फाइल आपने किया होगा, नहीं आया। तो चेक करिए भाई, इन लोगों का केस का रिटन सबमिशन सब रिकॉर्ड करें।
serial number 2. फाइल
सिनोप्सिस कहाँ दिए?
आपने नहीं दी, आपने दिया सर के नीचे फाइल
अच्छा फाइल किए हैं, ठीक है, आ जाएगा।
तो लगवा
आ
दीजिए,
जाएगा।
15 तारीख को होगा।
Orders with defect item 5. Procedural filing number 8903 of 2024.
I have filed ignoring the defect number. It is now number 183.
डिफेक्ट नंबर
183.
182. What is 183? What is this defect about?
Defect melody. Office pointer was appeal value and shoot. They want.
What is defect number 183?
Defect memo में appeal value should value.
डिफेक्ट नंबर 184 है इसमें।
184 में they want.
दोनों डिफेक्टिव है, 183 एंड 184।
184. One already filed.
So why is it showing defective? Surviving defect. समीर जी, इसमें देखिए ऑर्डर लिखा हुआ डिफेक्ट नंबर 183 पॉइंटेड आउट बाय द एसआर इज देयर। उसके बाद आईए हैज बीन फाइल्ड इन कनेक्शन विद इग्नोरिंग द डिफेक्ट। उसके बाद रिपोर्ट रिगार्डिंग कोर्ट फीस विल बी डन आफ्टर डिफेक्ट नंबर 183 एंड 184 इज। इसका क्या मतलब? ऊपर लिख रहे हैं कि ओनली सर्वाइविंग डिफेक्टेड डिफेक्ट नंबर 183, नीचे लिख रहे हैं दोनों के बारे में। ये आपका आईए कौन सा आईए नंबर? What is this IA and what is the surviving defect? What is the surviving defect?
183.
183 क्या defect है?
इसमें जो appeal value असुर award value.
हाँ, तो क्यों नहीं लिखा? उसमें defect क्यों ignore करना?
नहीं, इसमें जो देखिए award जो certified copy जो निकला है, यार में भी appeal value नहीं है। और सूट जो मेमो ऑफ जजमेंट जो है, जजमेंट में भी सूट value नहीं है। इसलिए
तो अपील वैल्यू आपकी तरफ से कुछ होगा ना? This is arising out of what?
इसमें मुझे इसमें सेक्शन 30 में हम ये चैलेंज किए थे, अंडर सेक्शन 30।
Compensation है ना? तो आप you are the claimant, correct? आपका कितना क्लेम है उसी अनुसार लगाइए अपना अपील वैल्यू। अवार्ड में नहीं है तो क्या हो गया? Tell us. You tell us. What is your claim? You calculate it accordingly. समझ गए? इग्नोर नहीं होगा क्योंकि that is the reason, उसी के अनुसार आपका कोर्ट फीस डिसाइड होना है। ठीक है? तो कोर्ट फीस कैसे डिसाइड होगा? और 184 क्या है?
184 जब अपील वैल्यू लिखेंगे तो उसके बाद कोर्ट फीस को ये करेंगे।
लिखिए फाइलिंग नंबर FA8903 of 2024. Learned Counsel for the Appealant has submitted that IA number 7155 of 2025 has been filed for ignoring defect number 183. The learned counsel has submitted that due to non-mentioning of award value in the award, it is not possible for the appellant to remove the defect mentioning the suit value and the appeal value. The matter arises out of land acquisition proceedings. This court is of the considered view that since the appellant is claiming enhancement of the awarded amount,
सेक्शन 30 में किए थे
Okay. This court is of the considered view that the award has already been passed for a specified amount, and therefore there cannot be any problem for the appellant to quantify the appeal value as per his own calculation. At this, the learned counsel for the appellant submits that some time may be given to remove the surviving defect. He has also submitted that so far as defect number 184 is concerned, the same also relates to valuation. Considering the aforesaid submissions, the IA number 17155 of 25 is dismissed. The time for removal of defects as granted by order dated 2/5/2025 is extended till 11th of July. If the defects are removed within the extended period, post this case under appropriate heading on 16th of July. Preemptory ही रह जाएगा. Preemptory पहले था, extend कर दिया. Preemptory ही रहेगा.
Item 6, first appeal filing number 3378 of 2025.
Yes.
So there are two defects. We have filed an IA 6174 for ignoring the defects.
Both the defects.
Yes,
What are those defects? Defect number?
defect number 25 B and C. That performer respondent number 14 of this memo is not a party in the implementing order. And number 2 is performer defendant number 30 of certified public implementing order is not made party in this memo. What is happening in
13 and 14.
Yes, sir. What is happening in the that the implementing order in which they have written the name of the original party, which is respondent number 13, but they have died during the pendency of the suit, which has been substituted also. We have written in the
Substituted when? They were party in the appellate proceeding.
Yes, yes.
Where is the appellate court sitting?
But they died. And
When did they die? During the pendency of
during
appeal.
the pendency.
Which appeal? This appeal or first appeal?
First.
They must have been substituted.
Yes, sir.
So then their name must be appearing in the appellate court's decree.
Inadvertently, they have written it. They have not substituted the main party.
Inadvertently, the substituted names is not reflecting in the
Yes,
decree.
yes, yes.
Then under such circumstances, decree is to be corrected. How can this defect be ignored?
It's written, and it's handwritten.
Where is it? Where is it?
Page number 58.
58. Defendant number 9.
30. Dr. Harnath Chakraborty.
13. Dr. Harnath Chakraborty. And the defect is in connection with respondent number.
Respondent number 13, 14.
Respondent number 30.
We are written in para 5 of the IA also. That the
You
performance-
come to page number 58.
Yes, sir.
Ramakrishna Sen had expired, correct?
Yes.
You have Kundan Sen, Tutu Sen, Ashok Sen, Jhuma Sen, right?
Yes.
How is Ashok Sen a party? He is son of late Virendra Sen.
Virendra Singh.
And who is Virendra Sen? Ashok Sen does not, his name is not appearing in the substituted list. Ashok Sen is number 10.
Number 10. Yes. You mentioned the defect is related to the respondent number 13.
Only 13.
13. You are performer respondent in this petition, which we have read. The legal access.
Just a moment. No, it is with respect to respondent number 14 also. You have not seen the office note. FA number, filing number FA 3378 of 2025. Counsel for the appellant has submitted that. नहीं, आइए तो दोनों के लिए फाइल की है।
Yes, yes, yes.
घर पे आइए पढ़ने का भी टाइम नहीं मिलता आपको। मेंशन किए ना? Yes.
Sir.
FA filing number FA 3378 of 2025. During the course of hearing, it appears that the appellant has not even gone through the interlocutory application seeking, ignoring certain defects as pointed out by the office. Post on 15 July.
For admission, atomic contempt civil 949 of 2024.
You have not gone to them to file the documents?
That has been filed.
When? When have you filed it? Nine filing. उसके पहले what happened ultimately? Have they furnished the documents?
They were required to furnish before the university.
University has filed an affidavit.
Yes, we have
Or
filed
you-
affidavit that we have given letters, email.
And ultimately it was understood on the last date, as I remember, that they would be going and doing the review.
Nothing has been done so far as we are. My instruction was that the documents have still not been given to us.
Content case civil number 949 of 2020. Counsel for the respondent university
Yes.
has submitted that the petitioner has not yet furnished the required documents.
And it shall see
In spite of repeated request for the same. Counsel for the petitioner prays for time to seek instructions. आप अपना appearance क्या बोलेंगे? Next Friday को डालिए, post on next Friday. आप instruction लेके आइए and file an appropriate affidavit with respect to this submission. You have to file your affidavit whether you have submitted, not submitted, and what is your problem in not submitting the document. इस फ्राइडे नहीं, नेक्स्ट छुट्टी है तो उसके बाद वाले फ्राइडे 4 जुलाई
From daily list for final disposal, item 1, first appeal 46 of 2023.
Appellant. FA number 46 of 23. Nobody appears on behalf of the appellant. Yes.
Just for 2 cases. IU was filed for the additional evidence in 3 weeks' time. The participant
To response. FA number 46 of 23. Counsel for the parties are present. Counsel for the respondents pray for and is granted. Further 3 weeks' time by way of last indulgence to file a response to the interlocutory application seeking to adduce additional evidence by alien number 433 of 2025. आपको पहले भी टाइम मिला 8 April 2025. Earlier time was granted to the respondents by order dated 8th of April 2025. Let the reply be filed latest by 11th of July, failing which no further time will be granted. Post on 15th of July.
For admission, item 7, first appeal 318 of 2023.
FA number 318 of 2023. Nobody appears on behalf of the appellant. Peruse the records. The matter has been posted for admission. There is no further office objection in connection with this first appeal. The matter arises out of partition suit. The suit seeking partition of property. Admit, call for LCR. Records from the concerned court. Let notice be issued to the respondents for which requisites under speed post as well as ordinary process. For which requisites under ordinary process with respect to respondent number, with respect to the respondents except respondent number 2, who is a resident outside the state of Jharkhand, be filed within a period of 2 weeks from today. So far as respondent number 2 is concerned, let notice be issued upon her through speed post, for which requisites be filed within a period of 2 weeks. Office to track speed post delivery and prepare appropriate office notes with regard to service of duties. Post this case on 31st of July, awaiting service report. Since the appellant is absent, let a soft copy of this order be communicated to the counsel for the appellant to ensure compliance. Premti कर दीजिएगा. Date डालें. 31st July तक बोले हैं ना. 31st July. इसको सॉफ्ट कॉपी भेज देंगे भाई.
Item 8, first appeal 126 of 2024.
This is also for admission.
Yes.
LCR उसमें क्या गया? देखिए FA number 126 of 2024. Nobody appears on behalf of the applicant. There is no further office defect in connection with the appeal, except that certain corrections have been carried out by the appellant in viewing instead of reading. Such objection is ignored. Admit. Call for records from the concerned court. Acha, records are there. The records, it has been reported that the records have already been received. Issue notice to the respondents. Through ordinary process, except to respond number 22, who is a resident outside the state of Jharkhand. The requisites be filed within a period of 2 weeks. Entry. So far as respond number 22 is concerned, let notice be issued through speed post, for which requisites be filed within a period of 2 weeks. Office to track speed post delivery and prepare appropriate office note with regard to service of notice. Let a soft copy of this order be communicated to the counsel for the appellant to ensure compliance. Preemptory order है on 31st awaiting service report. 31st July. What are you looking for?
If master permit there is one indulgence I am paying.
Indulgence means you are going to mention it.
Yes.
Rejected. Call to me.
Can I take a
For-
second now?
No.
For hearing
You should have been there at 10:30.
for hearing under order 41/11, item 9, second appeal 302 of 2016.
Yesterday I made a request to Validity.
In this case,
Yes, second day I am ready losses and when we are applied for getting certified copy losses.
सॉफ्ट कॉपी है ना रिकॉर्ड का दे दीजिए. बताइए सॉफ्ट कॉपी दे दिया आपको कब करेंगे बताइए.
Next week हम कर देंगे.
आप बस आर्ग्यूमेंट के लिए तैयार हुआ करिए.
Yes,
ये
yes.
सर्टिफाइड कॉपी और ये सब चीज़ की चिंता मत किया करिए. ठीक है चलिए.
7 to 10 minutes.
यू वांट टू डू इट नेक्स्ट वीक.
Yes.
आप अपना मेल आईडी दीजिए या यहाँ से ले लेंगे ना. ये तो सॉफ्ट कॉपी यहीं से ले लेंगे ना. अभी हम लोगों ने दिया था ना किसी को. प्रोवाइड कर दीजिए. आप पेन ड्राइव लेकर आएंगे आपको सॉफ्ट कॉपी. ठीक है देखिए ऐसे नंबर 302 of 2016 at the request of the learned counsel for the appellant who had circulated advance notice seeking adjournment in this case. The matter is directed to be posted on next Tuesday. Post on next Tuesday.
Item 10, second appeal 499 of 2016.
Yes, appellant.
Yes, appellant is defendant lawsuit. Defendant appearance before the court of lawsuit. Plaintiff instituted partition suit number 44 of 19 lawsuit for
Just a moment. You are the defendant.
defendant lawsuit.
Sole defendant.
Suit was defeated.
Sole defendant.
No, there are pro forma. There are pro forma also.
But appeal has been filed only on behalf of one.
One Famida. Yes.
And what about rest? They are respondents.
Yes.
Okay. It arises out of partition suit.
There is not a partition suit.
Trial court decreed.
Trial court declared the suit lawsuit against the decree we prefer appeal lawsuit. Appeal dismissed lawsuit. First appeal dismissed.
So what is the question of law?
Yes, sir. My question of law is in four lawsuit. First is land is recorded in the common ancestor of the party is Sheikh Mohammed Bugs lawsuit. Sheikh Mohammed Bugs had 4 sons and 4 daughters. Muhammad Imamuddin was the plaintiff lawsuit and Abdul Ghaffur is the defendant lawsuit. And Soheb Mitra, both predeceased before his father lawsuit. And 4 daughters have not been included in the partition suit lawsuit. And the suit property is mentioned in the print is Hirapur Dhanbad lawsuit. And the other property is also situated at Varanasi lawsuit. But Varanasi property has not been included lawsuit.
So this is basically seeking partial partition.
Yes, this is a partial
Is it an admitted fact that there were property in
Varanasi
Banaras?
lawsuit. Yes, lawsuit.
Is there any legal bar that there cannot be any partial partition?
Because they have mentioned also the suit property, the rest of the property which is situated at Banaras lawsuit that has been distributed among the daughters lawsuit. If they are admitting that already there was partition lawsuit, then again they instituted partition suit 1990 lawsuit. And my contention is lawsuit that Schedule B property is self-acquired property of the defendant lawsuit. We have purchased by sale deed lawsuit, that is Exhibit C lawsuit, through sale deed 11/5/1942. Sheikh Mohammed Bugs, who was the common ancestor of both the parties, also father's lawsuit, who died in the year 1935, and the father of this defendant lawsuit purchased this property on 11/5/1942. So this was his self-acquired property lawsuit and cannot be included in this partition suit lawsuit. And one son of the Abdul Ghaffur lawsuit, defendant lawsuit, who also instituted a suit lawsuit, title eviction suit against the sole plaintiff Muhammad Imamuddin lawsuit. Muhammad Imamuddin contested in the suit lawsuit and claimed his ownership lawsuit. He lost before the trial court, appellate court, and also in the first, and also before this honorable court lawsuit, before this high court also lawsuit. So this perfectly that the Schedule B property is the self-acquired property of the sole defendant lawsuit. My substantial question of law may kindly see lawsuit.
Now, make so vague substantial question of law. Which substantial question of law are you referring to?
Second is daughter have not been included as defendant in the suit lawsuit.
It must have been dealt with by the court as to why they have not been.
Yes, you kindly see lawsuit how the trial court did the issues lawsuit. Kindly see the issues lawsuit. First, page number 24, running page 24 lawsuit. First, start from page trial court judgment page number 8 lawsuit. Issues on recast lawsuit. Issue number 3 may be kindly see. Is the suit barred by limitation?
How a partition suit becomes barred by limitation?
Yes, lawsuit. Because they in the trade lawsuit they are admitting lawsuit that there was a previous partition lawsuit.
Not, there was no, do they admit that there was a previous partition with
Yes,
respect to the entire property? No. They say that there was some kind of arrangement or partition with respect to property
Yes.
at Banaras.
No, kindly see the para 10, para 10, 12 and 13 of the print lordship. Now you cannot read out this.
I
Para
don't
10,
have the plane with me.
para 10, 11 and 10, 12 and 13 lordship.
I don't have the plane with me. It's just not there.
In the para 10 lordship, they are stated lordship that sometime after the death of Abdul Ghaffur, his grown-up children started creating trouble in their family, and for better understanding and good relations by Muhammad Imamudi, the plaintiff partitioned the house property of Gandhinagar in 2 equal shares. And kindly, para 12 lordship, that the property partitioned by the caste Panchnama is described in Schedule A below. Both the co-sharer after partition of the property, they started possessing separately by living therein and by letting out the portion of the monthly tenants. That despite of partition of the house properties by meets and bounds, as mentioned above, some of the sons of late Abdul Ghaffur are not satisfied. Hence, the property described in Schedule A of the suit has also been included in the suit for partition for decision of the matter once forever. अगर हम अब्दुल गफूर के सन्स हम लोग हैं, अगर हम लोग सेटिस्फाइड नहीं रहते पार्टीशन से, तो हम लोग पार्टीशन सूट फाइल करते हैं, वो क्यों फाइल करते हैं? And trial court lordship erred in giving the share to the daughters 3/7 lordship, although they are not exist on the they are not existing as party lordship. How the suit will be how the decree will be demarcated and the share will be allocated to the
Share
daughters.
has been allocated to
Yes.
the sisters also without
Sister.
making them party.
Yes, without including the party lordship. Kindly see 3/7 share has been given to the daughters lordship, although they are not party lordship.
Where is the finding with regard
Yes.
to misjoinder of party or non-joinder of party?
Yes.
Issue number 5. How has that been dealt with? Issue number 5.
Issue number 5. Issue number 5, page 36. Finding is page 36. The defendant have taken the plea that the suit is bad for non-gender of necessary party as the four
Internal page बताइए.
internal page
Internal page trial court judgment.
36.
Internal page 21 की 36.
36. Issue number 5.
Issue number 4. Issue number 5. Yes.
Issue number 5.
You were the defendant.
Defendant.
You were claiming that it was your self-acquired loss.
Self-acquired lawsuit. So we have purchased the procedural lawsuit, that is Exhibit C lawsuit. In the year 1942 lawsuit. Although my father
You
died
have
lawsuit.
purchased the Schedule B property.
Schedule B property. Exhibit C lawsuit, schedule number 3823 lawsuit, 11/5/1942 lawsuit. 1 एकड़ 60 इसमें परचेस किया. फादर तो मेरे फादर का डेथ हुआ 1935 में, इसके बाद 7 इयर्स के बाद में परचेस किया. एंड PW1 ऑल्सो गवाही में भी आया, एविडेंस में भी आया हुआ है. PW1 भी खुद बोल रहे हैं कि हम लोग भी वासेपुर में जमीन में भी परचेस किए. सो ऑल द पार्टीज परचेस लॉटशिप अकॉर्डिंग टू देयर कन्वीनियंस लॉ. सूट प्रॉपर्टी में मेरा 2 स्टोरी 3 स्टोरी बिल्डिंग ऑलरेडी बना हुआ है. first appellate court not given any finding lordship, just mentioned the evidence of the parties lordship and not given any finding, not out of 4131 of the CPC has been compared to the first appellate court also.
Where is the substantial question of law? But एक के बाद एक पढ़िए. Read your substantial question of law.
Page 92 lordship. Whether current court below has committed grave error of not dismissing the suit filed by the respondent when according to the case of plaintiff Sheikh Mohammed Gus had two sons and daughter who are entitled to their own shares in the suit property, but doctors have not been included as defendant in the suits. Whether the learned court below has wrongly interpreted that the doctors cannot inherit the shares on the death of the deceased female and under the Mohammedan law in a partition, they are not necessary parties and for non-gender of the said doctors, the suit could be dismissed.
2 का तो रहने से तो 3 will become redundant. 2 should be sufficient. 3 is not important.
Yes, yes,
Correct?
yes,
2 will cover your point.
yes.
और आगे 4.
Fourth, whether the learned court below has failed to consider that the plaintiff respondent claimed partition for suiting A properties on the basis
Plaintiff respondent. अच्छा, okay. The plaintiffs were claiming the partition of Schedule A property.
of Schedule A and B properties. Schedule A property on the basis of two share deed of 1922 and 1923, Exhibit 6 plus 7. But surprisingly, the share deed do not contain khata number and plot number, but the plaintiff have inserted it and
Inserted मतलब? Share deed में कैसे insertion होगा?
हाँ, share deed में मेंशन नहीं किया हुआ है. यहाँ पे जो claim relief में जो rate में अपना मांग रहे हैं, उसमें वो खाता नंबर प्लॉट नंबर मेंशन कर रहे हैं. Exhibit 6 and 7 में खाता नंबर प्लॉट नंबर मेंशन किया हुआ नहीं है. अपने मन से कैसे उनको पता चला खाता नंबर प्लॉट नंबर ये कैसे सूट में मेंशन की हुई रिलीफ पॉलिसी में. Next, whether the learned court below has failed to consider Schedule A property does not have any boundary and the plaintiff have not made any attempt to compare it on the basis of two share deed of 1922 and 23. Next is whether the learned court below has committed grave error of law in giving 3/7 share to the daughter in their absence as party in the suit. In the evidence also come lordship, the one PW1 Muhammad Atik lordship, he himself stated lordship. He has also purchased some property in Wasepur in Dhanbad also, but that property has not been included in this suit also lordship. So this suit is also bad for partial partition lordship.
All properties were not included.
Not included lordship. And Schedule B, which is a self-acquired property lordship, has been included. And the learned court below wrongly given the
Schedule B is the self-acquired property of the
of the
defendant.
defendant lordship. Defendant Abdul Ghaffur,
Abdul Ghaffur.
They are the legal heirs of Abdul Ghaffur.
When did Abdul Ghaffur purchase it?
Abdul Ghaffur purchased on 11/5/1942 lordship, which is Exhibit C lordship. 1 acre 60 display lordship.
Or the learned counsel appearing on behalf of the appellants. And who was Abdul Hamid?
And Abdul Hamid is my his son.
Son of Abdul Ghaffur.
Abdul Ghaffur. He instituted a title eviction suit against plaintiff for eviction suit. He instituted eviction suit. And Muhammad Imamuddin appeared in the suit
Just-
contested as
Counsel for the appellant has submitted that the appellant was a defendant in the partition suit. And appellant is widow of late Abdul Hamid, who in turn was son of Abdul Ghaffur. The counsel for the appellant has submitted that the daughters were not made party in the suit, but the learned court has earmarked share of the daughters. And was of the view that non-joinder of daughters in the suit was not fatal to the proceedings. He has also submitted that the specific case of the defendant, that Schedule B property was the self-acquired property of Abdul Ghaffur, has not been properly considered by both the courts. He has also submitted that the records would reveal that all the properties were not included for partition, and the plaintiff sought partition of only Schedule A and Schedule B property. He has referred to the suggested substantial questions of law as framed in the memo of appeal, and in particular, he has referred to substantial question of law number Roman 2, Roman 5, check करिए.
yes.
Roman 6, and Roman 9. हो जाएगा? Roman 9, Exhibit C उससे cover हो गया, अब्दुल गफूर का property.
Yes, exhibit C.
This appeal is, after hearing the counsel, this appeal is admitted for final hearing on the aforesaid substantial questions of law. जो नंबर बोले हैं उसको
जी जी
issue notice to the respondents. सब झारखंड के हैं? प्लीज चेक. बाहर वालों को ऑर्डिनरी प्रोसेस का नोटिस
Yes,
देते
yes.
हैं. ये सब तो नहीं है झारखंड.
धनबाद केस.
एक नहीं. Except respondent number 28, Badru Nisha. Under ordinary process for which requisites be filed within a period of 2 weeks from today. So far as respondent number 28 is concerned, let notice be issued through speed post for which requisites be filed within a period of 2 weeks. Office to track speed post delivery. Let the records be called from the concerned courts. Suppose this case on 11th of August, awaiting service.
Item 11, second appeal 40 of 2023.
Yes.
We are the original defendant. Concurrent finding of the both the courts.
So,
In prayer, my lord, the plaintiff, my lord.
you are the plaintiff,
No, I am the defendant.
you are the defendant.
Original defendant.
Original defendant, you have lost in both the courts.
Okay.
It was a partition suit. What was its
My
nature?
lordship, it is suit for declaration that HIPAA bill, the registered HIPAA bill ever gave it, my lordship, is whether legal valid or not.
Okay.
That is the prayer. And
The suit was decreed.
yes, my lordship, decree it was held valid, my lordship.
That particular document was under challenge.
Yes,
What is your ground?
my lordship, the trial court, my lordship, have held that the registered HIPAA bill ever number 415789 is a legal document.
Is
Is a legal document, is valid. The trial court gave a finding, my lordship. Thereafter, the first appellate.
no trial court? You say decreed the suit, no?
Yes,
So that must have been set aside. Cannot be revoked or cancelled by donor.
That
So that particular document was sought to be cancelled by donor,
Yes,
and you are the donor.
yes, I am the original defendant, the defendant.
You were only defendant.
Yes, I have died, my lordship, my substituted substitution.
Okay.
So, the trial court has decreed, my lordship.
How the donor would revoke
My lordship,
the gift?
I
Under what provision of law? Gift is a complete transfer. It's a registered gift.
registered it, but trial court has, appellate court, my first appellate court, has reversed this finding. The trial court, the first appellate court has held that it is not HIPAA being evers, it is pure HIPAA.
So,
My lordship, HIPAA being evers is for sale of for
Exchange.
consideration.
sorry,
HIPAA being evers means sale for consideration. There must be some consideration for
some
registration.
exchange.
Some exchange consideration. There must be consideration. It has the aspect of sale. But first appellate court has reversed this point. The first appellate court held that the HIPAA being evers is not a complete document because there is no consideration. So that if it is not valid. It has gave a finding. However, my lordship, the first appellate court has changed the nature of the registered document and said that it is pure HIPAA. It is not HIPAA being evers. Whether a registered document can be unilaterally changed by the court.
The unilateral. They must have interpreted the document.
My lordship, a
It
registered
is not.
document.
It is not a matter of changing it. The
They
document
have-
can certainly be interpreted.
My lordship, because it is registered document. It is registered.
No,
Punjabi
even if
law.
it is a registered document, it can be interpreted by the courts. Then what is the true nature of the document? Where is the illegality in it? It is not something that they are rewriting the document. Have they rewritten the document?
My lordship, they have simply changed its nature.
No, they will not change it. They, upon interpretation, they must have found it of a different nature.
Upon interpretation, it was found that it is HIPAA, but it is registered as HIPAA being evers. It is the whole case of the
Title will
plaintiff.
not decide the nature of the
My simple only one point, my lordship, whether registered HIPAA being evers, which is a conditional agreement, it is like a character of agreement for sale. It must have consideration. That can be changed into HIPAA. That is my sole, my lordship.
So everything is revolving around the interpretation of HIPAA bil Ivaz.
Because it is a registered document.
Where is the finding of the learned trial court and the appellate court with respect to this document?
Whether first I go to appellate court, I
Trial court. Which issue is relating to interpretation of this document?
Issue number 5 and 7 are jointly dealt. Is HIPAA being evers number 4157 of 89 valid, legal and binding upon the defendant.
And what is the finding?
I'm just start from page 55 of the trial. Internal page 57 of 70. Trial.
57 of that. Yes, read it.
Is the HIBA waivers number 4157 of 89?
It is not matching. Internal page 57.
Internal page number 37 of 70.
37. That's right. This is the issue. Where is the ultimate finding?
Starts from 37.
Defendants are also supporting the case of the plaintiff. The defendant witnesses have also supported the case of the plaintiff, isn't it?
My own position is like whether it can register document can be changed or not. This issue has not been dealt with, and I have tried my best to find out. This issue might not be. Because it is a registered document, there must be a consideration. How can we change it? Because for an agreement there must be two parties. Both parties should agree, might not. Then only anything can.
Where is the ultimate finding with respect to this issue so far as the trial court is concerned?
Page 58 of 73, in light of the above discussions, it is concluded that plaintiff has proved that on dealing on the facts matter.
Yes.
The plaintiff have proved that facts relating to the issue number 5 and 7, while the defendant has not proved the fact of the defense of the defendant, and therefore plaintiff has successfully discharged the onus cast upon him. Consequently, issue number 5 and 7 are decided in favor of the plaintiff and against the defendant. Thereafter, issue number 6 was dealt whether it can be revoked or not.
And where is the finding of the learned appellate court?
Page 23 is the point of determination framed by the first appellant court. Internal page 23. Thereafter, I'm starting dealing with Yes,
So he says that there are two transactions.
Paragraph 24, Madam Chair.
They say that there are two transactions. Give to each other. This is what the finding is.
Page 35.
Page number 29.
29. Madam Chair, that has been concluded in paragraph 24, page 35 or 44 of the first appellate.
Where is the point of determination?
Point of determination, Madam Chair. Page 23 of 44, internal page 23, point of determination. Whether the Hibabi neighbors dated 1989 excluded by Afzal
Sorry,
SP.
page number?
Page number 23 of 44, appellate court.
23. Yes.
Whether the Hibabi neighbors dated 1989 excluded by Afzal say defendant in favor of the Vedana Bibi plaintiff respondent is valid as per Mondal law. This issue is answered in page 35. After taking all the aspect of the Mondal law, page 35 of the protocol, paragraph 24.
Yes.
Now coming to the first point of consideration as to whether the Hiba bill can be revoked. Yeah, can I find neither there is pleading in plain nor the government made a written statement that any consideration or property was transferred by the donor to the donor. All the witnesses produced either by plaintiff or the defendant had unequivocally stated that Hiba was excluded only amount of service rendered by the donor to the donor, and there is no transfer of consideration by the donor to the donor. Thus, essential ingredient of the pursuit of gift as Hiba has not been fulfilled, as already referred to the judgment of the Honorable Privy Council, absence of proof of consideration being paid to the donor, even though gift document refer to the transaction of the consideration, the sale deed of the gift will not be treated as Hiba bin Evers, but simple gift, that is Hiba, which is delivery of possession is necessary. Here, Madam Chair, the first appellate court reversed the finding, Madam Chair, said that it is pure Hiba, it is not Hiba bin Evers. That is all my also contention, Madam Chair, whether it can be changed, the registered document, nature of registered document can be changed.
That has been interpreted, but the appeal has been dismissed. Appeal?
अपील डिस्मिस हुआ है, कंप्लेंट फाइंडिंग है, अपील डिस्मिस हुआ है, ट्रायल कोर्ट में भी हमारे, अपीलेट कोर्ट में भी हमारे,
ट्रायल कोर्ट में हारने का क्या कारण है? यहाँ तो बोल दिया कि हिबा बिल
ट्रायल कोर्ट तो प्लेंटिफ के फेवर में हुआ है, so I lost that.
That's right. ट्रायल कोर्ट में आपके हारने का क्या कारण है?
हिबा बिन एवर्स को वैलिड कहा गया है.
And the appellate court, while upholding the judgment, has held that it is a hiba and
हिबा,
not.
हाँ, रजिस्टर्ड डॉक्यूमेंट रजिस्टर्ड हुआ होगा उसको.
देखिए, कौन सा substantial question of law है?
और whether Madam Chair,
Which substantial question of law are you referring to?
substantial page of 15 का 6.
15. Page number 15 तो ही नहीं इसका.
सेकंड अपील का, सेकंड अपील का.
Second appeal का ही देखिए. और कौन सा पेज नंबर?
पॉइंट नंबर 6 में इसका फाइल मिसप्लेस हो गया तो रिकंस्ट्रक्ट किया इसकी पेज whether despite finding of the
कौन सा पेज नंबर? Where is the substantial question? Your memo of appeal is running in just 7 pages, 10 pages along with the certificate. Which page should I refer to? Which page should I refer
page
to? आप
15
page
15
115 है ही नहीं इसमें. मेमो ऑफ अपील है। सर्टिफिकेट का पेज नंबर कौन सा?
18 इसका फाइल मिसप्लेस हुआ तो रिकंस्ट्रक्ट किया उसके वजह से शायद
आप पढ़िए तो अपना सब्सटेंशियल क्वेश्चन ऑफ लॉ कहाँ बना है?
whether despite finding of the lower appellant court that the said gift was will not be treated as hiba benevers when the pleading is hiba benevers, then differing suit cannot be sustained.
देखिए second appeal number 40 of 2023. The learned counsel for the appellant submits that the appellant was the defendant in the suit and has lost in both the courts. The bone of contention between the parties was registered Iba bin Ibaz, bearing number 4157 of 1980. The learned trial court held that the Hiba bin Ibaz was valid and the learned first appellate court held that Hiba bin Ibaz was not the nature of document, but it was simply Hiba. The learned counsel has submitted that in spite of recording that the said registered document will not be treated as Hiba bin Ibaz, which was the specific case of the plaintiff, would the learned first appellate court still sustain the judgment, still dismiss the appeal? यही है?
Converted into hiba.
The learned counsel for the appellant has referred to substantial question of law number Roman 6. ये internal page 7 में. Having heard the appellant and having gone through the improved judgments, this appeal is admitted for final hearing on the following substantial question of law. Roman 6. Issue notice to the sole respondent for which requisite under ordinary process be filed within a period of 1 week. Let the records be called for from the concerned court. Pose this case on 31st July of 1872.
For hearing, item 12, second appeal 352 of 2016.
पास ओवर कितना दिन में पास ओवर के लिए बोले? हाफ एन आवर में ना? यस, द पास ओवर फॉर
You should have taken instruction in this matter, taken the consent of the senior advocate as well. I have to only bring matter to be posted day after tomorrow. Meanwhile, I'll brief this.
You start meeting, we will post it day after tomorrow, don't worry. You engage your senior only on law points. Facts you can place,
Consent, please.
you place the facts, you place the contours of the case.
I am also not very well prepared. I can only place the facts at this
I'll
point.
impose cause then.
So yesterday evening only, Your Honor.
Where is your wakalatnama?
It's in the process of being filed.
You first file that wakalatnama. We are at 40 to 12. You go through the records, we'll hear it at court. Right? That should be enough. आप पढ़ लीजिए. आपसे मैंने specific question पूछे. Oral gift. What are the basic ingredients of oral gift? And whether those ingredients are satisfied on the basis of materials on record. First thing you need to read the plaint, written statement, any date given, not given, and by the witnesses to the oral gift when not examined. Is there any explanation to that effect? थोड़ा सा oral gift बहुत doubtful लगता है.
And Lordship, the most important part is that contrary to the oral hiba, the ground for mutation is something else.
हाँ, that we have seen.
If you had a
And written submissions की एक extra copy को.
I'll just,
बस आप पढ़ना शुरू करो.
I think the file when given must have been given that also. Have you received that written arguments?
yes,
Is
मिला
there?
है आपको?
The file has been written in totality. File has been written in totality.
List of arguments.
Yes, this
हाँ.
one and the
एक written argument का अलग से.
अलग से.
But it will take some time to.
It will take time. You have to read the plaint and the written statement. It will take time. But you have to start.
Indeed, well, still I am praying. Let this matter.
I am also praying to you. But start reading the file and let us
Yesterday I
read
would
the
have not
judgment.
accepted the wakalatnama had I the knowledge it would be listed today. And I have gone to the previous
Once you
order
receive the
before accepting.
wakalatnama, don't you see the uploaded orders?
Your Lordship, I have seen the previous orders, Your Lordship. By the previous date, the process of notice was done. I could not find any orders in which the.
दिखाई जरा ये ऑर्डर अपलोड नहीं करते क्या?
नहीं, it is uploaded. I've got
अभी
the
अभी
copy.
हम अपने ऑफिस को पहले शो कॉस्ट करेंगे. आपको बाद में बात करेंगे. This one.
It is factually incorrect.
Order dated 9/6/2025, uploaded on 10/6/2025 with a clear indication that the hearing will go on for 2 days. And yesterday, I am sorry that I was not there because I was not well yesterday.
That was the.
Right? I can call sick any time, no? सिर्फ आप ही लोग बीमार पड़े ऐसा तो कोई नियम नहीं है ना?
You should try to.
Otherwise, I give information in advance. But सुबह my BP was very down. I was not in a position to hold the court. ऐसा half-hearted तरीके से कोर्ट नहीं होल्ड कर सकते.
Indeed, Your Lordship. My apologies, Your Lordship. Only Your Lordship, previous to that order, Your Lordship, I could not find that there was time taken by.
There was another order also which says that
So
for
I
final
presume that
decision.
I will be getting an indulgence after receiving the brief. That was
Your
the
diligence is also missing.
I completely had no idea.
आप शुरू करिए आप ऐसे नहीं.
Lordship could see the order of 27th March.
To assist Your Lordship.
27th
No, you have to start your argument. कम से कम अपना सीनियर को क्या ब्रीफ करेंगे उसके लिए भी तो पढ़ना ही पड़ेगा ना. हाँ तो पढ़िए.
And this is the best indulgence he could get from the court.
हो सकता है आप जीत जाएं. सीनियर की जरूरत ना पड़े. Possible.
I'm a bit slow learner. I have to.
I'm slower than
sure.
you.
I'll be able to.
I'm slower than you.
I am the slowest.
ऐसे नहीं चलेगा.
I'll try. Your Lordship.
You see, reading a
This
first
is the
appeal
indulgence.
file
Please,
takes quite some time even for the judge. एक फाइल को 10 बार पढ़ना मुझे पसंद नहीं. Okay? इसीलिए हम लोग साथ
For
साथ
that
पढ़ेंगे.
reason, Your Lordship, I was not trained for much time. Only day after tomorrow. Your Lordship.
Day after tomorrow दूसरा केस फिक्स्ड होगा ना भाई. How is it possible?
But I.
Please appreciate one thing. When I read a file, I may not be reading the other files on board. Then you want me to take up a case which I have not read? बिना पढ़े तो हमको आदत नहीं है कोई भी केस करने का. एडवोकेट थे तभी भी नहीं आदत थी और जज बन के तो बिल्कुल ही कोई स्कोप ही नहीं. Particularly when the proceedings are online.
With this little time, Your Lordship, I'll not.
आप सोचिए आपका क्लाइंट क्या सोच रहा होगा आपके बारे में कि आप अपलोडेड ऑर्डर भी दे देंगे.
I've seen that.
You have not seen it.
I was
Have you
under
seen
the
9th of
impression-
9/6/2025 order?
Yes, Your Lordship,
Then-
I've seen that order, but prior to that order, Your Lordship, I could not find orders in which it reflected that the applicants have taken time before.
How does that make
I
a
was under the
difference?
impression one indulgence.
How does that make a difference? One indulgence is not your right.
Indeed, Your Lordship, that's not my right. That was my presumption.
You come at 250. Just 250 कोई और केस नहीं रखे हैं ना. हम लोग रखे हैं कोई और केस नहीं है ना. बस पूरा सेकेंड हाफ इज डिवोटेड टू यू.
बच्चों.
पढ़ेंगे समझेंगे थोड़ा.
I'm not able to point out everything, Your Lordship.
कोई
That
बात
is the difficulty I'm facing.
यू मे नॉट. वो तो लास्ट मोमेंट तक भी नहीं लोग पॉइंट आउट कर पाते.
बच्चों.
अभी 1-1.5 घंटा पढ़िए 2:15 बजे तक. ऐसा मौका जीवन में रोज रोज नहीं मिलता. You are very lucky today that your senior is not there. वकालतनामा फाइल कर दीजिए. यहाँ पे फाइल कर दीजिए. एक और पास ओवर है, किसका पास ओवर है?
Item 1. Item 1 from supplementary list. Second appeal 309 of 2016.
Can I pray day after? But I can, because very short question I can directly answer. But your lordship, yesterday evening and today morning I went through got two more judgments of this honorable court. One was division bench, another was, so that would have an
I'll
impact.
tell you one thing. These kind of issues, आप घर पे कितना ही पढ़ें, जब तक हम लोग साथ नहीं पढ़ेंगे तब तक नहीं
हाँ
होगा.
ठीक है.
Start placing it.
हाँ, because
एक दिन में वैसे भी हम नहीं करेंगे, आपको पता है.
otherwise your lordship, very clear case. It was
So
a case where your lordship would recollect.
I
whether-
remember, I have heard it at length.
Yes.
थोड़ा सा हम लोग देखते हैं.
ठीक है.
कम से कम सेकेंड अपील में क्या रेस्पेक्टिव केस का पार्टीज था, what were the findings and the issues. उसके बाद we'll see. First we'll read the substantial question of law, and then the trial court and the appellate court. And if anything, any evidence in particular you want this court to see, you should indicate.
So, being actual question that would be involved is whether the female would have a right to inherit. This is the only question on which the entire appeal would depend.
That's right.
So, if that is answered, your lordship, it is actually very short. The
Let us
answer
see.
is actually very short.
Let us see the question of law
Yes.
framed. एक चीज है मिस्टर राहुल, इन सिविल लिटिगेशन शुरू करने से ना थोड़ा सा फाइल खोलने में
नहीं,
थोड़ा हेजिटेशन
हमको-
होता है, because these are very very lengthy matters. But once you open the
नहीं,
file
वो
and
नहीं,
we are all at
because-
the same platform.
Because I do understand my responsibility that this would have an impact on many other cases. That is the reason
Therefore,
that
we
I
have
am
to be
so
all the more
cautious about it.
careful. You can start it today.
Yes.
We can post it for further hearing day after tomorrow.
Yes.
I may have a few queries. So उस दिन queries अपना consider करके हम लोग अपना या तो reserve करेंगे या लिखाएंगे
ठीक,
या
ठीक।
कुछ करेंगे. ठीक है?
ठीक.
One is on order 41 rule 31. वो तो पहले frame हुआ था,
हाँ.
है ना? Does it survive or you want the core issue to be decided?
Order 41 rule 31 was not gaining. That was the reason that your lordship I said that second question of law was formulated.
Now the second question of law has been framed.
Yes. Yes.
By order dated 6th of May.
Yes. Yes.
So should I record that the substantial question of law framed under on 1/11/2018 may not arise?
Your lordship may.
ठीक है? बताइए. Any objection to that?
He would be benefited because
Yes,
of
it will
that.
not arise in this particular case.
Correct?
Correct.
पहले तो ये लिखा.
And because the question of law which my lord has framed, whether arrest custom among the Santals debarring females from the right of inheritance over the land left by the ancestors satisfying the test of binding custom as has been laid down in the case of Lakshmi Bai such as. Lord, the parties, so far as the custom is concerned,
So we'll come to that. First is
I'm just two little points now. Both the parties have not disputed. What was the dispute actually? He was claiming the rights to the Bhajamai. And the trial
we'll
court
see
said,
that, Mr. Sharma. There are two substantial questions of law framed. One would call a remand, right? Order 41 rule 30.
Non-compliance of
Non-compliance of the provision. Normally we remand the matter.
that's why I'm saying that. So far as the custom, this custom, that in the tribal community, there is after the death, it is the Agnes who claims. For that only a Bhajamai, through Bhajamai, he can
Mr.
be
Sharma,
claimed.
I am on a different platform altogether. I just want to know whether the first substantial question of law arises for consideration or we can just skip that.
It does not arise. That's
So I will
because
just
there
record
is
it.
already answered to that.
Okay.
Well answered so far as the appellate court is.
It is concurrent findings?
yes.
Concurrent findings. So you would like to say that
No, it's
That-
not correct.
Reversal.
Judgment of reverse.
The trial court has dismissed the suit. It is the appellate court which has reversed it. And the trial court has said that there is a Garjamai form of marriage which has been reversed and said, she was in the ordinary form of marriage. So, as such, there is no right. That is as per the tribal custom. My friend from these submissions I will show. He has not disputed it. Now the question, Your Lordship, which my Lord has said, that alleged custom among the Santhals debarring females from their right of inheritance over the land left by the ancestors satisfies the test. So far as the question of law which has been framed in this particular case.
Let me hear you. Let me hear you. You have objection to this question of law also? I think we have heard you.
I have objection to this question of
No,
law.
we have heard you. We have heard you.
My Lord, I am on that day also.
We have heard you on
Yes.
this. Now
My
let
Lord
us
has
see.
said that I am open to this.
Certainly.
And thereafter this was framed. But I had repeatedly said on that date also that so far as the custom part of the civil is concerned, that is in admission. Now the question is that the only question which was to be decided by the learned trial court and learned appellate court, whether they will get a right through the my form of marriage or the ordinary form. That was his case.
Let us see. Let us see.
Yes.
You just have some patience. Yes.
Why I conceded to the first question was because, Your Lordship, the appellate court has discussed in detail, and the trial court had said, but Your Lordship, whenever compliance of order 41 to 31 would arise, now each and every line of the trial court is not required to be dealt with by the appellate court. Then in such circumstances it would be very difficult. Each and every judgment of the appellate court would be faulty. So it has to be seen whether while even reversing or concurring with the findings of the trial court, the appellate court has reasonably exercised its mind on it.
That's
And whenever the appellate court reverses, particularly in those cases, the appellate court must deal with the main points
there has
which
to
are
be a substantial
whether-
compliance. of
yes,
this.
and whether at times there would be cases where points for determination are not framed, and if the appellate court, if it instead of formulating points for determination, it deals with the issue wise, then also it would be treated as sufficient compliance. So on that aspect, if each and every judgment would be faulty on that. Therefore, I conceded to the first one.
Let's
Now, the second question of law that was formulated was whether the alleged custom amongst the tribals debarring females from their right of inheritance over the land left by the ancestors satisfied the test of a binding custom as has been laid down in Lakshmi Bai through so and so versus Bhagwan Goa reported in 2013 for 1997. So this is the main question that would have
It is 1997 or 997?
190.
97.
97. So before Your Lordship deals with, Your Lordship may see the plate. Suit was filed by them, and what was there in the plate then. Your Lordship may allow me to read the entire plate.
Yes, yes. I think at the time of framing also we had read that.
Yes.
Yes, please.
plaintiffs as well as defendant, first party and pro forma defendant, belong to Santhal Christians by caste, and they are governed by Santhal customary law in the matter of inheritance. That neither Hindu law nor Mohammedan law is applicable to Santhal Christian community. Now here your Lordship therefore had asked us, posed a query whether there was any such Santhal Christian community or not. It is not there, it is either Santhal or any other. Then according to the Santhal Christian customary law of inheritance and ordinary, here I will pause here. Here it says that according to Santhal Christian customary law of inheritance, there is no such Santhal Christian customary law of inheritance. It is Santhal customary law. An ordinary married Santhal Christian daughter of a deceased Christian Santhal is not at all entitled to inherit her father's property. In such a case, if the sonless Santhal Christian dies, his property will pass on to his agnates, and his agnates shall be entitled to inherit his movable and immovable properties after his death. So, here, accordingly, even if their statement is taken into account, they say that there is some Santhal Christian customary law of inheritance. Then they have to bring which was that Santhal Christian customary law of inheritance. Then that is not the Santhal customary law which has been referred to in Ganges. It is something else which they are pleading. Because Ganges report says only with regard to Santhal customary which are applicable to only Santhals, not to Santhal Christians. That the plaintiff and the defendant first party as well as the pro forma defendant are the descendants of Ticket Murmu, since deceased who had his Jamabandi land in Magrudi, yes, so and this Ticket had died before the MacPherson's settlement, that the relationship of plaintiffs as well as the defendant first party and of the pro forma defendant would be evident from the following genealogical table. Karu Murmu, according to their case, was the common ancestor who had two sons, one Ticket and second was Harma, and in Harma was the recorded tenant under whose name was recorded in Jamabandi number 30 of Ganjar settlement, and according to their own case, Juba Murmu was the only daughter of this Harma, and Juba had one son who is the Kadu Hasda, and then their descendants.
Kanu Hasda, it is mentioned daughter.
Husband. He is the husband.
Kanu
He is the
husband of
the husband of Juba, and they had a son which was Kadu. So Kanu is the husband.
And they had a son called
named Kanu. And then the other defendants are their
No,
descendants.
they had a daughter called Kanu. Daughter लिखा हुआ है genealogical table में.
नहीं. D means died.
Oh, D means
D means died because your Lordship would find Juba
Kalu is the son.
daughter is mentioned.
Okay. D means died.
So the right side of the branch, that means Harma was recorded tenant of Jamabandi number 30 is not in dispute.
Yes.
This is there in statement in the plaint itself.
Yes.
Another undisputed fact is that Juba was the daughter of Harma,
Yes.
only daughter, no other brother. And then Juba, whatever, was married to Karmu or not, and then their descendant is Galu and other defendants are there. So Juba being daughter of the recorded tenant is absolutely not enough. What is now, they claim that Ticket was the brother
Kalu
of
also
Harma.
died. Who was the plaintiff?
Plaintiffs are the descendants of Ticket.
Descendants of
Ticket. That means they claim that Harma had a brother named Ticket, and Tickets, they are the descendants of Ticket. This is their claim. Therefore, I may be allowed to read further. that the relationship of so and so is mentioned, then your lordship may kindly skip to
Kindly let me
Para
note down.
6.
Kindly let me note down.
yes.
Okay.
In RWS, we have disputed the ticket was brother of Harma, but I'll come to that.
Okay.
That Harma, para 6. Harma Murmu, son of Kanur Murmu, recorded tenant of Jamapandi number 30 of Ganjar's settlement, separated himself much before the last Ganjar settlement from his agnates and co-sharers. Karu Murmu of Jamapandi number 3, Purva Murmu of Jamapandi number 3, Harma Murmu of Jamapandi number 3, and as such, during last Ganjar settlement operation, the said Harma Murmu, son of Karu Murmu, was recorded under a separate khata being Jamabandi number 30 during the Ganjar settlement, and his other co-sharers and agnates, Karu Murmu, Kora Murmu and Harma Murmu, all sons of Tikat Murmu, were recorded jointly under khata Jamabandi number 3 of Moja Mangrudi during the last Ganjar settlement operation. That so here your lordship may also take note of this statement in para 6 that according to plaintiff's own statement, they say that before the settlement operation, Harma Murmu had already separated from his agnates and co-sharers.
That's it.
So
he is not claiming a joint family property.
yes. So here he says that they are already separated, and now what their claim is that because he had died without any son, therefore this would revert back to them. This is ultimately their claim. But here they very clear admission that they are separated. Then para 7, that the reported tenant Harma Murmu's son of Karu Murmu of Jamabandi number 30 died sometime past, leaving behind him only daughter and only issue Joba Murmu, who was married with Kanu Hansda in ordinary form of village Kalipur, Ranga Sonsa. That after the death of Harma Murmu, the recorded tenant of Jamabandi number 30, the plaintiff being his nearest agnate, legally inherited the land of concerned Jamabandi number 30 according to the Santhal customary law of inheritance to which the parties belong and come in possession of the same. That it may be mentioned here that the Joba Murmu, son of daughter of Harma Murmu, who was married in ordinary form with the said Kanu Hansda, all along lived with her husband in her husband's house at village Kalupur Ranga, P.S. Jama, and both Joba Murmu and her husband Kanu Hansda died there, leaving behind a son Galu Hansda. This also I'll show that it is false because Galu Hansda has been recorded as Nati Rayat he has been recorded in the property belonging to this
Joba's
Harma.
Harma's
In Harma Murmu's property, his name has been recorded to be in possession. So obviously he was there in possession, therefore his name was recorded as Nati Rayat.
So there, according to you,
Yes.
their claim that they were in possession of the property is also not correct.
Yes, not correct. Because in settlement operation, he was recorded as Galu Hansda, Nati of Harma. That the Galu Hansda also died in his paternal house at village Kalipur Ranga, and P.S. Jama died, leaving behind his three sons, Johan Hansda, Yakub Hansda, and Peter Hansda, who also died in their ancestral house at village Kalipur Ranga, leaving behind them the defendants of their heirs as their heirs. That neither Joba Murmu nor their husband Kanu Hansda, nor their son Galu Hansda, nor Galu Hansda's son, said son Johan Hansda, Yakub Hansda, and Peter Hansda nor the dependents were or are heirs and successors of the recorded tenant Harma Murmu according to Santhal customary law of inheritance, nor they have ever exercised any possession over the land of said Jamabandi number 3. That the suit land appertaining to the said Jamabandi number 30 of the said Mauja Mangrudi PS Jama, which has been fully described in Schedule A of the and the converted plots of the present settlement of has been described in Schedule B, given at the foot of the plaint, and the same forms part of the plaint. That the defendants are rank outsiders and they have no manner of right over the said suit land, nor they have ever exercised any legal possession over the same. That it may be submitted that at the time of commencement of the present settlement operation, the said Johan Hansda, Jakub Hansda and Peter Hansda, all deceased sons of Galu Hansda, predecessor of the dependent first party, behind the back of the plaintiff, bought the suit land wrongly and illegally recorded in their name in collusion with the survey staff of the present settlement operation under Khata number 10 of the said village Mangrudi PS Jama. So here I'll pause again. So first this Harma Murmu was recorded in possession. Then his Nati, that means Galu's name was also recorded in Khatia. And then in subsequent survey operation, this the name of the 3 descendants of the same Galu Hamda, it was recorded. So they continuously were in possession of it.
Even as per the plaintiffs.
Yes.
So,
Absolutely.
but they at one point they say that they came in possession and such
They
recording
say-
was incorrect.
But they say that this statement is contradictory to the survey records.
That's
That the suit land appertain to the said Jamabandi number 30 of Mauja Mangrudi, PS Jama, which have been fully described in Schedule A, and the converted plots of present settlement have been described in Schedule B, given at the foot of the plain, and the same forms part of the plain. That the defendants are rank outsiders and they have no manner or right or title over the suit land, nor they have ever exercised any legal possession over the same. That it may be submitted here when they say that they have not exercised any legal possession over the same, that means they are in possession, it may not be legal. In para 13 what they are saying.
They say that they were dispossessed in 2003 and thereafter the cause of action came.
Yes.
Is there any finding with regard to cause of action?
No separate finding there.
We'll see that.
Yes,
We'll see that. What is the finding regarding possession is also important.
yes.
Continue please.
That it may be submitted that at the time of commencement of present survey of settlement operation, the said Johan Hamza, Yakub Hamza and Peter Hamza, all deceased sons of Galu Hamza, predecessors of the dependent first party, behind the back of the plaintiff got the suit land wrongly and illegally recorded in their names in collusion with the survey staffs of the present settlement operation under Khata number 10 of the village so and so, PS Jama. That after getting their names recorded in the Khata number 10 of the present settlement operation, the said Johan Hamza, Yakub Hamza and Peter Hamza, all sons of Galu Hamza, recently in 2003, came to the village Mangrudi and started living in the house of the recorded tenant Harma Murmu forcibly and wrongfully. And after their death, the dependents have also been continuing their residence in the house of recorded tenant Harma Murmu forcibly and wrongfully. Now this was the statement. I'll show that it was only for the purpose of filing of suit and I have my learned friend rightly pointed out, Your Lordship, there was an amendment in 14A was inserted. That 14A, I may be allowed. That recorded tenant Harma Murmu had 4 daughters, namely Juba Murmu, Budni and Jagni by so and so, the present settlement authority and the genealogy given in the plaint as Joba Murmu, only daughter of recorded Harma Murmu, be remained, and the names of the three daughters be added in the genealogy of the plaint along with Joba Murmu. 14b, that Galu Hansda, son of Juba Murmu, had been taken in adoption as per order of settlement authority dated so and so, as document of adoption has been shown to the present settlement authorities, and accordingly final parcha of the present settlement of Moja Mangrudi has been prepared and issued by the present settlement authority in the name of the dependents and others, which is not correct and illegal.
Now there is a story of adoption also.
Adoption also according to them. Now, even assuming that he was not the naturally born son of this lady Joba, then also according to their own statement he was adopted son. Although this, I'll show that it is incorrect, but then also their own statement that he was adopted son. So even if he is ultimately adopted son, he is a son. After adoption he has all the rights of a son.
The entry made in the record of rights was under challenge.
Yes, which was in the name
And
of
they thought
these three persons, the
and they
sons of
sought declaration
Galu.
of the right title and interest.
Yes, yes. Your Lordship
What was
has
the
seen.
written statement?
Your Lordship has seen the
I've
reading portion. Yes. Then the written statement.
One written statement or multiple written statements?
The first party written statement.
Who are there two set of parties? One to five has
Actual
five.
contesting is 1 to 5. Dependent first party.
Chunnu Hansda. Anyways, read this written statement of defendant number 1.
1 to 5 is the actual contesting written statement. That save and accept what has been specifically admitted in so and so, the defendant first party emphatically deny all the claims and allegations made in the plaint by the plaintiff and put them to strict proof of the same. That with ulterior motive, the plaintiffs have falsely described the defendant number 1 and 2 as residents of village Kalipur Ranga, when alike their father and paternal uncle and grandfather Galu Handa, they were also born and are residing at village Mangrudi, and none of them ever lived at village Kalipur. That the plaintiff had no locus standi to maintain the suit, and other two, the suit is not maintainable, that the suit is hopelessly barred by limitation, that the suit is also barred by principles of acquisition, that the statement made in para 1 of the plaint is only partly correct. The correct fact is that Harma Murmu, son of Karu Murmu, and his daughter Juba Murmu and her husband Karu Hasda were not Christian, and it appears that it was Galu Handa, the grandfather of the dependent first party, had become Christian, and since then the family of dependent first party are Christian. That the statement made in para 2 of the said plaint are not denied, that the statement made in para 3 of the plaint are only partly correct. It is submitted that there is no Santhal Christian customary law of inheritance. As stated in para 3, the correct position is that Santhal tribal law of inheritance given in para 46 of the Ganjar settlement report also applied to Santhal Christian in the matter of inheritance and succession. From the said para 46, it would also be evident that the law not allowing females to inherit inheritance was changing owing to force of public opinion. Even during the time of Ganjar survey settlement, and the daughters not married in Gargamai form also inherit paternal properties, and contrary statement made in para 3 of the plaint are not correct. That the except the fact that the plaintiff and the pro forma defendant number 6 are descendants of Ticket Murmu, who had also his Jamabandi land in Magrudi, Jama, and he had died before Macpherson settlement, and other statement made in para 4 of the plaint are false and baseless, that the genealogical table given in para 5 of the plaint and the statement made in the said para alleging that the said dependent first party are relations of the plaintiff are wholly false and baseless, and the same have been concocted to falsely claim the suit land. It is further submitted that Ticket Murmu was not the son of Karu Murmu, as has been shown in this said table, that the statement made in para 6 of the plaint are imaginary and entirely false. Harma Murmu had no agnet or co-sharer, and hence never had the occasion to separate himself from his alleged agnet and co-sharer much before the last Ganjar settlement or at any time. In this connection, it is submitted that since before the Wood settlement, Ticket Machi or Murmu and Harma Murmu had no concern with each other, it would be evident from the last settlement Parcha of Jamabandi number 3 of Mauja Mangaluri, which belonged to plaintiff, corresponds to Macpherson settlement Jamabandi number 13, and Macpherson settlement Jamabandi number 30 corresponds to Wood settlement Jamabandi number 10. It may be stated that Macpherson settlement Jamabandi number 30 was recorded in joint name of 3 sons of Ticket Murmu, and the Wood settlement Jamabandi number 10 was exclusively recorded in the name of Ticket Murmu. That others had last.
I couldn't get this. What does it want to say?
Yes, it mentioned that in the earlier settlement, only Ticket Murmu was solely recorded, and in the subsequent settlement, it was recorded in the name of his only 3 sons. Here we mean to say that if they were brothers, Ticket and Harma were brothers, then in the earlier settlement, their names would have been jointly recorded. They were never jointly recorded in none of the settlements. Therefore,
So you want to say that Ticket is a outsider?
Outsider, and he is not the son of Karu Murmu. Whereas Harma is the son of Karu, but Ticket is not the son of Karu.
So therefore they claiming being the agnet.
Yes, is not correct.
But
And therefore there was no question of separation. Therefore this statement has come. Therefore there was no question of separation.
that's right.
That the other hand, the last settlement, Jamabandi number 30 of village Magrudi, as well as corresponding Macpherson settlement, Jamabandi number 22, were recorded exclusively in the name of Harma Murmu. That the statement made in para 7 of the plaint are partly vague and partly false. The plaintiffs have motivatedly made vague statement that the recorded tenant Harma Murmu of last settlement Jamabandi number 30 died sometime past, when in fact he had died about 4 or 5 years after the last settlement, leaving behind his only issue and daughter, namely Joba Murmu, whom he had got married in Jharkhand form with Kanu Angda, when all the customary ceremonies, including so and so, Lebeta Churi, I am not aware of it, were also performed and kept in the said Garjamai married daughter and the son-in-law in his house, who on his death had inherited his properties and possessed the same. Thereafter, only son Galu Hanta possessed the properties till his death in or about 1951. Whereafter his, it is handwritten, Your Lordship, whereafter his 3 sons and there the dependent first party are coming in possession of the suit land, that the statement made in para 8 of the plaint are entirely false, imaginary and baseless. As submitted above, the plaintiff or their predecessor were not agnates of Harma Murmu, the recorded Rayat of last settlement, Jamabandi number 30, and on his death, his Gharjamai married daughter and his son-in-law had inherited and possessed the said properties of Harma Murmu, and after their death, their son Galu Hamda inherited the said properties and paid rent to village Pradhan. That the statement made in para 9 of the plaint, 9 and 10 of the plaint are absolutely false, and the same have been concocted to lay a false claim to the suit land. As submitted above, Harma Murmu had got only his only issue and daughter Joba Murmu married in Gharjamai form and kept his Gharjamai married daughter and son-in-law in the house, and both of them continued to live in the village Mangrudi in the house of Harma Murmu and died leaving behind their son Galu Handa, who also lived in village Mangrudi like his parent and possessed the suit land. It may be stated that all these three sons of Galu Handa were also born at village Mangrudi, and they also lived and died there and possessed the suit land and paid rent to the village Pradhan. And it is totally false that the dependent first party and their predecessor ever lived at village Kalipur Ranga, and Johan Hansda, Yakub Hansda and Peter Hansda had died in village Kalipur. That the statement made in para 11 of the plaint are wholly false and baseless. Admittedly, Joba Murmu was the only issue and daughter of Harma Murmu, whom he had married in Gharjamai form and kept her and Gharjamai's son-in-law in his house, who being his legal heir and inherited the entire properties, and on their death, their son Galu Handa inherited.
In the written statement, you say that Joba Murmu was the only daughter.
Yes.
But in the amendment, they introduced that there were multiple daughters of
It is their claim. It was initially their claim that Joba was only daughter, which they later
which
on.
they amended
Yes.
by saying that she had number
Yes.
of daughters.
Yes.
That there were number of daughters.
Yes.
It was amended as because in the survey purposes, at the time of recording of the name, actually they had said that
Whatever be the reason.
that
But
was the
initial
opinion.
suit was that she was the only daughter.
Yes.
Written statement was that she was the admitted fact that she was the only daughter.
Only
So they are
But there was an amendment. There was an amendment in the plaint, and you also filed written statement.
They filed additional written
There is
statement.
an
They
additional
said,
written statement. Not
Not
correct.
So far as the adoption is concerned, they were because they were claiming that there were 4 daughters, and adoption was the occasion for the value itself. That was the reason we have brought those amendments. That they have filed additional written statement.
Yes, it is there, but they are denying this fact.
They are denying. They are denying. What we are saying.
There is
that-
one more para 14B. 14B has not been introduced. There were 2 paragraphs.
Plain.
In the plaint, there were 2 paragraphs which were added, 14A and 14B.
And both are additional written statement and
Dealt with
both are
both.
in dealt.
Initially,
Yes,
they were
14B has
claiming-
also been.
Yes. And the
Initially, they were
statement.
claiming through Gharjamai form. Later on, they also claimed by virtue of that adopted son. So that was the occasion for it.
No, they have not raised that plea in the written statement that
No,
they were adopted.
They denied it. But
No, they denied means what? They never said so.
no.
In the written statement, their case was that she was the only son and they have inherited through her.
Yes.
It was
But-
an admitted
but-
fact that
but-
she was the only
but
son.
This fraud, but this when this fact came to our notice, then out of yadas, then we brought those documents also on record, and before bringing those documents, we amended our plaintiffs. Those have been
No, I
taken-
don't get it. They filed a suit. The suit was filed by saying that she was the only daughter. In the written statement, they admitted that she was the only daughter. But subsequently, the plaint was amended, and there was a story of adoption and further daughters of
Yes,
Hanmu.
the occasion for that was
No,
that
whatever be the occasion, but subsequently it came which they disputed.
yadas in the yadas
Now-
yadas
Now,
document.
considering the contours of the question of law, we
Yes.
will not enter into any kind of evidence in connection with the whatever
Both
finding
the
has been recorded.
Both the courts have concluded that there was only one daughter.
One
that is
so
Job.
that's it.
Job.
It makes
Yes.
no difference. If there is a finding of fact
Yes,
recorded
yes,
that
yes.
Joba was the only daughter,
Only-
matter ends.
For a matter ends.
That amendment has got no relevance.
Even the adoption also.
Adoption also has got no
the matter
relevance.
ends.
Let's forget
Matter
it.
ends.
So
Yes.
there is a concurrent finding that she was the only daughter, Mr. Rahul. Is that correct?
Yes,
Yes.
and very fair of him.
Yes, yes.
And
He is
that
always
was-
very fair. ठीक है, the suit में issues बना. Now let us see for the dispute involved, which is the core issue. पहले उसका देख लेते हैं.
So before placing that,
Yes.
now your lordship, from the written statement, your lordship would find two things. I have taken alternative plea, and that is not bad. My alternative plea is that he was married in Ghar Jamai form, and therefore he otherwise also inherited. And even if it is not proved that he was married in Ghar Jamai form and he was married in an ordinary form, then also we have relied on on the Kanjar's report, which recognizes that since the law was changing, so even otherwise being a daughter of the original recorded tenant, Joba was entitled to inherit the properties of this.
And regarding the law which was governing, they said that it was a Christian Santhal law.
There is no such
There is no
Christian
such
separate,
Christian Santhal law.
absolutely not. But let us assume that the same custom was, the same Santhal custom was governing them also. Let us assume that also. Then also,
No, because you have taken a specific stand that they are covered by Santhal customary
Yes.
law, and there is no such concept as Santhal Christian
Christian,
customary.
we have taken very, but let us
What is the
assume,
finding in that?
yes, let us assume that it was Santhal customary
Is there
law
any
which
finding?
was binding.
Is there any finding to that effect that the parties are governed by Santhal customary law? It is one, Mr. Rahul Gupta, it is one thing to say that there is a finding that they are governed by Santhal customary law, and whether that customary law has been proved or not. These are two different stages altogether. Is there any finding that they are governed by Santhal customary law?
Yes, that finding.
That finding is there. Okay. Now you just issue number 6 is a trial court issue, which would be relevant. Maybe 5 and 6 both, because 5 is dealing with Garjamite form of marriage.
Trial court concluded that it is not
4 and 6. Issue number 4 and 6, they were
4
taken
and
up
6 have
together.
been dealt with in
Together.
page internal page 5.
That's
4 is whether the Harma Murmu had 4 daughters and got one daughter, namely Joba Murmu, married in Garjamai form, and the 6 is whether are the plaintiffs legal heirs of Harma Murmu and have inherited the properties of Harma Murmu.
What is the finding, whether there was a marriage in Garjamai form?
It was, the trial court said that it was.
It was not married. And thus it is clear that, no, trial court, what was the finding of the learned trial court on this? That's right. Defendants have proved that their inheritance of property of Harmu Murmu on the basis of Gharjamai form, right? Then,
Trial
so entry in record of rights does not warrant any interference.
survey entry appears to be proper and plaintiff could not be able to prove that the plaintiffs have inherited the properties of Harma Murmu, recorded tenant of so and so. Rather, defendants have proved their inheritance of the properties of Harma Murmu on the basis of Garjamai marriage. Thus, these are
The cause of action was also denied. So this story of forcible possession appears as concocted story and not believable. Internal page 12 at the bottom.
Yes, yes.
So the story of forcible possession was also disbelieved. The entry in record of rights was found to be correct. And then it was found that they were in Jamai form of marriage. So you have also proved your possession through the various rent receipts.
Yes.
Exhibit A to 27
And
were the
this,
various rent
this
receipts.
disposition, they say that it occurred in 2003.
That
No
has been
FIR,
disbelieved
no-
by the learned tribe.
No FIR, no complaint whatsoever, and the suit was filed after 3 years.
After 3 years of
3 years,
disposition.
yes. Alleged disposition.
Now you read this. Before concluding the issue, I would like to discuss the page number 12.
Really. Before concluding the issues, I would like to discuss the cited case laws on both sides. Just. If your Lordship would allow me to read a paragraph earlier,
Okay.
para 10.
Can you read?
On going through the pleadings, evidences and argument of both the sides, it is apparent that none of the parties has brought on record about clear-cut date of death of Harman Murmu, nor they have brought the year of death of, or even approximate marriage of Joba Murmu, nor any such witness who may say that he has signed the marriage of Joba Murmu. So the findings regarding ordinary or Gharjamai marriage will be concluded on the basis of happening circumstances acted upon. The plaintiff has pleaded that Harman Murmu died some year past of Ganjar settlement, whereas the defendants pleaded that he had died about 5 years after the Ganjar settlement. Likewise, no paper has been brought on record which make clear the ticket was the son of Karun. Here important finding is. Likewise, no paper has been brought on record which make clear that ticket was the son of Karun. So the finding about Agnes will be concluded on the basis of analysis of circumstances suggested through documentary and oral evidence. From oral evidences of DW 1 and 2, it has come that marriage of Joba was in Gharjamai form, but during the cross-examination, they were not able to say who has seen that marriage. Likewise, PWs could not say about witnessing of ordinary marriage. Documentary evidence DW D to D5 suggests that family members of defendants are voters in village Mangrudi. This is another important. On perusal of this voter list, it is apparent that some of the members of defendant's family are voters in village Mangrudi in between 1966 to 2005, which indirectly indicates that defendant's family dependents are residents of Mangrudi, but plaintiff could not brought any such proof of dependents residing in village Kalipur Ranga. This fact suggests that Joba Murmu was residing in Mangrudi, and that is why her sons, grandsons and great-grandsons are residing in that village. This fact also suggests that marriage of Joba Murmu was solemnized in Gharjamai form, and that is why they were residing there, and entry in recent survey settlement made in the name of dependents of descendants of Joba Murmu also suggests that survey authorities have found the possession of the dependent's family. Before concluding the issues, I would like to discuss the cited case laws on both sides. On perusal of case law reported in 2007 so-and-so, it appears that this case law, the Honorable Apex Court has been pleased to hold about the 4 essential ingredients of custom to override upon the statute, that is, custom must be immemorial, it must be reasonable, it must continue without interruption, it must be certain in nature. This ruling must be taken as a guideline for considering customary law in circumstances of the case when the custom is proved without suspicion. From the point of the present case, both the parties concede on the point that in case of Gharjamai marriage of a daughter can inherit the property of her father, so this ruling is neither in favor of the plaintiff nor against the defendant. This case law cited by the defendant, that is 2009 so and so, also suggests where custom has been proved, then Santhal widow can adopt a child, meaning thereby where the custom in locality is prevalent, then customary law will follow as per the custom of the locality. In this regard, as mentioned above, about keeping the names of the descendants is not fully prevalent in the locality, which is clear from the evidence of PW7 para so and so of the custom cannot override on general law. The other ruling of dependent number so and so are not applicable for the present case. Rather, the two rulings are on different facts as well as so and so. From the consideration of several ifs and buts, but raised by the plaintiff, particularly regarding proving of Exhibit A to A727 and the custom and entries of survey reports, it may be said that these factors may be weakness of the defendant's case, but plaintiffs have to stand upon own leg. But except one rent receipt Exhibit 2, no proof has been given about their vestment of title over the land of JB number 30 of Arma Murmu, whereas defendants have brought several rent receipts Exhibit 8 to 827, and even some rent receipts by the defendant may be doubtful but not properly proved, then it was open for the plaintiff to produce documents supporting their case, and the plaintiff should stand on their own leg. Thus, there are several proofs in favor of the defendant to be continued in possession of the defendant over this land. Even if story of plaintiff about forcible possession of the defendant in the year 2003 be taken into consideration, then what prevented the plaintiff to lodge complaint about such overt act to police or court of law? So this story of forcible possession appears as a concocted story and not believable. Entry in recent survey also confirms the possession and inheritance of the defendant. So even in both cases, that is agnates or marriage, the possibility through evidence in totality as analyzed above suggests that the defendants have succeeded the property of Arma Murmu, and in such circumstances when the survey authorities find possession right and title of on the land, then the name of defendant or their father or uncle were recorded. So in any view of the matter, entry of recent survey does not warrant any interference. So the survey entry appears proper, and the plaintiffs could not be able to prove that the plaintiffs have inherited the property of Arma Murmu, recorded tenant, JB number 30. Rather, the defendants have proved their inheritance of the properties of Arma Murmu on the basis of Bharagami marriage. Thus, these are two issues are decided in favor of defendant and so on.
Appellate court.
Yes. Your Lordship, the finding actually starts in internal page 10. Paragraph would be para 10. After hearing the parties and going through the pleadings and materials on record, I find that there are three prime questions
These
involved
are
in.
the points for determination.
Yes. Pleadings and parties on. I find that there are three prime questions involved in the dispute between the contesting parties of the present suit. The first question is whether Jova Murmu, daughter of reported Harma Murmu, put in Gardamai form of marriage with Kanu Hamza of village Kalipur Ranga, so and so. The second question is whether the Harma Murmu and Tikat Murmu were full brothers, and the present plaintiff being descendants of Tikat Murmu are kindred and agnate of recorded tenant Harma Murmu. And the third question is whether the suit property recorded in the name of Chauhan Hamza, Yaqub Hamza and Peter Hamza, all sons of Dalu Hamza, in the recent record of right, exhibit so and so, new khata number so and so, Moja Mangrudi, on the basis of Yaddas number 447 Exhibit 1, prepared by survey settlement authorities of recent survey settlement, in which dependent number 1, inspired of the shown document and claimed before the survey authority that his father Ganu Anta is the adopted son of recorded tenant Harma Murmu, who had 4 daughters. In search of answer to noted the first question, I find that the contesting parties to the suit admitted and relied on their same customary law of inheritance by Santhal females prescribed in para 46 of Divisional Survey report of J.F. Ganjar concerning Santhal Pargana district of the year 1922 to 35, published by Superintendent Government Printing Press Bihar so and so in the year 1933. Our Honorable High Court in the case of Narayan Soren versus so and so, reported in so and so, has been pleased to discuss such customary law at para 45 and 46 of Ganjar report, which reads as under.
That you had read on the last date that it is partly quoted.
Yes. Then.
Which part has been omitted?
You
had indicated on the last date.
Yes.
Do you remember?
If your Lordship would have this.
Yes, Santhal Pargana tenancy act.
But your Lordship was referring on last
Yes,
occasion
I
that
remember
it is there in CLT Act, but
it is there in CLT.
no,
Not there.
no, because it is not within this Chota Nagpur area. Therefore, I tried to find out.
But I have quoted it in one judgment.
Some.
case, my lord has quoted.
I have quoted the entire
Yes,
text
it is there. It is.
in one judgment.
Your Lordship has quoted in.
Aradhan Murmu case that
Haradhan Murmu case, I have quoted it. So this is, there cannot be any doubt that this is partly quoted. And this has been picked up from another judgment.
Yes, and even otherwise it is, everyone relies on this, but it is there in.
ये नीचे ना SPT वाले नीचे ना संथाल पटना उनसे किताब
हाँ, इसमें है, इसमें
आप उसका वॉल्यूम 2 नहीं देखे थे उसका वॉल्यूम 2 CLT एक्ट का वॉल्यूम
नहीं, I have it.
दिखाइए ना this is volume 2
this is volume 2 because volume 1 is the normal one, your Lordship. This contains all the reports.
This is gangster survey report, right? We are looking at gangster survey report.
No.
हम लोग कौन सा सर्वे रिपोर्ट है?
वही गंजर का ही.
ये कौन से पीरियड का है?
ये सब दूसरे डिस्ट्रिक्ट्स का.
Your Lordship has recorded it is there.
हाँ, I've recorded it somewhere, I remember, but still book से देखना चाहिए. उसमें क्या आपको dispute है? उसमें recording में dispute है? Is there any error? वो judgment में जो मैंने quote किया है, is there any error? This property is from which place? कहाँ का property?
Santhal.
मैंने जहाँ से भी कोट किया होगा उसका रेफरेंस जरूर होगा उसमें.
Interest settlement reports in 27.05
27
ये वाला para 9 of this.
और आपकी उस किताब में है?
हाँ है.
और यहाँ पे जो कोटेड है इंप्यून जजमेंट में वो वाइफ तक कोटेड है ना?
सेकंड पार्ट भी कोटेड करता है.
सेकंड पार्ट कहाँ कोटेड करता है? इंप्यून जजमेंट में
और आगे भी लिखे हैं.
ओन होम विथ वाइफ. ठीक है, ये कोटेशन के बाद जो है फाइंडिंग उसको पढ़ते हैं हम लोग.
हाँ पर
ये मैं रख लूँ.
page 89 of this.
हाँ,
Page 89.
इसको जरा फोटो कॉपी करेंगे या किताब में लगाएंगे. हाँ, अभी आ जाएगा. हमको पता है, आई रेड इट, आई एम अवेयर. पहले 12 पढ़िए इसमें. ये लेटर पोर्शन को यहाँ कंसीडर कर रहे हैं, कोट नहीं किया. पैरा 12.
According to the authority in Santhal customary law, the male can only inherit the property, and the position of women in Santhal society are jinisnaku. That is just like an object. The Santhals are patriarchal and patrilineal people. Inheritance of property moves in the male line, but in exceptional circumstances, it can also go in the hands of female, but only temporarily. According to old Santhal tribal law, only males can inherit land. Some jointly succeed their father. If the brothers are co-sharer in a holding and one brother dies without issue, the surviving brother and the sons of predeceased brother inherits his share, and the general Hindu and Mohammedan law of succession do not apply to Santals, and Santal tribal law is quite definite in not allowing females to inherit. However, Mr. Ganjar's report says about some gradual change in such Santal custom. In this case in hand, the dispute relates about inheritance of the property of recorded tenant Harma Murmu by descendants of his daughter Juba Murmu on the ground that she was put in Garjamai in marriage with Kanhu Murmu of village Kalipur Ranga, yes, so and so. Thus, I confine my discussion only to the extent that how the Santhal daughter can put in Garjamai marriage and how she can become entitled to inherit the property of Santhal father. I'll pause here.
That is not the case of the
Yes,
written statement.
because in my written statement there was very clearly I had taken alternative plea also, which had been totally ignored by the applicant. At this stage, it is relevant to note that Santal law, the land transfer of land holding is restricted. A Santal Raya cannot transfer his right of his holding on any portion thereof by sale, gift, mortgage, will, lease, or any other contract or agreement express or implied. As quoted above, in the final report of survey settlement operation in the district of Santhal, Pargana, so and so, it sets forth Santhal customary law that any partition, inheritance, or marriage subject which, perhaps in view of clause C, section 23 of regulation 3 of so and so, should have been dealt with more fully in the settlement record of right of Santhal villages than it is accepted to have been done. If a Santhal woman is left as a widow without son, her husband's father or brother will get the whole property, and such widowed women cannot get some limited property temporarily. But if a woman, widow, has daughters, their paternal grandfather and uncle will take charge of mother and daughters, and the property will remain in their possession. When the daughters grow up, they will marry them, and at their marriage they will give them what present they would have got from their father, and they will support the mother until her death. And after their marriage of all the daughters, the widow will get the prerequisites of a childless widow, perquisites of the childless widow, and go to her father's house, or will go to and live with her daughters. If the widow is this, actually this portion is absolutely against the today's context. It says that until her death and after marriage of the daughters, the widow will get the perquisites of a childless widow and will go to her father's house or will go and live with her daughter. If the widow is with the son and she will keep all the properties in her own possession, and the grandfather and uncle can only properly look on to see that the wife does not waste the property. If the widow remarries before her sons are married, the grandfather and uncle will take possession of all the property, and the mother of the children has got no right over anything. However, there was change in customary law, and after the arrival of Christianity among Santhal, whether they are Christians or non-Christian, same law is applicable. Insofar as customary law of inheritance by a Santhal daughter by virtue of Bharjamai marriage, in paragraph 46 of Mr. Ganjar's report, it is prescribed that according to Santhal tribal law, only males can inherit son. Again, repetition, Your Lordship. After 2 lines, it says that according to Ganjar report, if there is change in tribal custom, and it is permissible for a man with daughters and no son to take son-in-law in his Gharjamai and to give him thereby all the rights of a son. The adoption of Gharjamai is a formal proceeding, leaving no doubt as to father-in-law's intention and resulting in a Gharjamai cutting off all connection with his own family as far as his property are concerned, and becoming all intent and purposes son of his father-in-law. When such adoption has been formally made, Gharjamai can succeed as a son and house other male relatives. It is of importance to note that the Gharjamai can be adopted only by a deliberate public act and in the presence of a village community, and at the time of marriage, and that according to tribal law, a father-in-law cannot later stage convert an ordinary son-in-law into a Gharjamai. A widow cannot in any circumstances create a Gharjamai. In Santhal customary law, there are different forms of marriage among the Gharjamai. Among them, Gharjamai and Ghardi-Jamai are 2 forms of marriage in which Gharjamai is adopted permanently like an adopted son in the house and of his father-in-law, and cut off all the relations for the purpose of inheritance from his natural family. But Ghardi-Jamai merely lives and labors in his wife's home for a previously stipulated period which may extend up to 5 years. He thereby works off the debt due on account of the non-payment of pawn, but Gharjamai is not entitled to anything but his from his wife's family. So there is clear distinction between a Gharjamai and Ghardi-Jamai. In both cases, the husband lives in his wife's home, but Ghardi-Jamai is not entitled to get anything from his wife's family. In the same authority of law, our Honorable Court, it is observed in references to the final report, survey settlement operations in the district Santhal Pargana 18 so-and-so, that it set forth Santhal customary law that any partition, inheritance and marriage subject, then in view of clause C, section 23, regulation 3 of 1872, it should have been dealt with more fully in the settlement record of right of Santhal villages than it is accepted to have been done. Lordship's library must have the gazetteer, Your Lordship, because Ranchi gazetteer and other gazetteers were there. The red color book, bold compilation.
Yes, it must be.
I'm also trying to get if there. Santhal gazetteer, अलग से है. Because so many references of these settlement of 1898, 1907 is coming, but I could not get it anywhere.
Must be in the gazette report itself, but that is not.
Is there any finding that Ticket was the agnate of Harman? Was the brother of Harman? Is there any finding by the learned appellate
He
court?
has framed that issue, but
Is there any finding to that issue?
That is the finding recorded on the documents as well as on the basis of the oral evidence that he is the evidence. And my friend on the last occasion was also arguing that this was one of the point of law, but my lord has said, this is not, and I will be permitted to read it if you worship.
That's not.
That finding is already there. Otherwise, there is no question for any inheritance of that too on account of evidence. If they are not against, there is no question. So against, though the trial court said that they are not against, but the appellate court has said no.
But this judgment is not taking care of the fact that certain observation was made regarding change in customary law, etc. But it is not taking care of the fact that what was the observation made regarding inheritance of women, the observation that we are looking for. That observation has not been considered here at all. They are talking about some other change in law.
yes.
Regarding Ghar Jamai form of marriage
exactly.
and regarding Ghardi Jamai form of
Yes,
marriage,
yes.
etc.
But
But
not
this aspect of the
Yes.
matter is
Is
not
not
taken
no,
care of.
nowhere.
Nowhere. I was just
Because
reading through.
Your Lordship took note of the earlier portion.
Both the courts, the trial court as well as the appellate court, my friend has not argued even, and no evidence to that effect is also on the court.
What evidence? You see, the fact remains that the property is to be recorded in the name of the son of the sole daughter.
No, that is what the appellate court has said. That is not proper, as because. If he was a Ghajamai, that what is their case, then the name
No,
of
you forget about Ghar Jamai. You see,
in that case
I'll-
was fought
I'll-
like fought
no,
like
there is
I'll
an
conclude
alternative
and he
plea
may-
in the,
that
there
case
is an
was fought
alternative,
like that.
maybe it was fought like that, but the court confines it to one aspect of the matter. Why should the court confine?
What as because as per the order 14, if there is a pleading, if there is a denial, then the issues are there, and on the issues party adduce evidence, and even the argument is addressed on that. My friend though had raised something like one or two line in the 46, there was a shifting change or something like that. But what change actually occurred? What right they got, and nothing like that. Merely because some pleading is there, but there is no such that was not issues.
If there was no such argument and no
No
such
issues, there were
discussion,
no issues there.
what was the occasion for the court to confine it to the plea that it is Ghar Jamai form of marriage?
My lord, we kindly issue.
That to the first appellate court.
Madam, because the pleading is like that. That part I will read. That part why he has confined it. That is there itself. The reason was that they were themselves fought on the whole litigation fought on two counts. First was that they said no, it is the Gajavai form of marriage because it is also well settled through the customs and age old customs that once a Gajamai is taken into force, then he is like a son, and his name should come into records of rights. But in the whole documentary evidence, my lord will find that his name did not appear in the records. So that is the reason, my lord, one of the major reasons, and not only he was a resident of village Rangapur. We have brought on record, my lord, the records of rights of that place, my lord, where their names has been entered. And the learned appellate court has taken into consideration that it is one of the very important ingredient of a Gajamai, that once you become a Gajamai, you will have to break off with the natural family. And because these ingredients were not available, and my lord, the learned trial court did not consider, my lord, the tribal law itself, my lord. There, on that count, your lordship, the finding has been reversed. That it was never in the ordinary form, rather it was in the ordinary form, it was never in the Gajamai. That was the main, my lord, the plank on which the defendants were contesting us. And so far as the entry in the records of right, your lordship, is concerned, recent entry in the records of right, my lord, as because Ismail Malad Handa, who is one of the contesting Malad defendant, he had appeared before the revenue authority, and he had said like that out of four, that he had four daughters, and on account of that his name was entered. And we not only that, we got upon Malad, first we made Malad the pleadings, thereafter we got upon Malad that the Adas report, when a competent officer or revenue officer has also deposed. Taking all these considerations, the London Trial Court has concluded that Gajamai, as a Gajamai, he had no rights. And so far as the question of law is concerned, which this court has already framed, my friend has never argued that they are not governed by the tribunal. His case is that he is governed by a tribunal. Now the question is, if any such there is any shift like that, or any crystallization like that, then only such deviations can be done. I agree to that proposition, but that the law should be like that. But the question, Lordship, also that comes to my mind: if there is a society, if there is a custom, and it is being followed for more than so many years, then it has attained a force. Unless and until there is a legislation that too by the parliament. Madhu Kishwar case, the issue with respect to Chota Nagpur Tenancy Act was there, and the Honorable Court has not declared it a latra bias. There is a major judgment, though there was a dissenting judgment, but the majority judgment, your Lordship said, is there is bias, and in proper case, the parliament should enact law. My lord has also said like that. In one of my judgment, one of the judgment which my friend has argued, that part, your Lordship, so many judgments, after considering so many judgments, the Honorable Court has also said like that. Question, your Lordship, on this issue. The Learned Appellate Court has said the very important point, your Lordship, is 23C of the Santhal Regulation 1872. If that is,
He has not yet finished.
if that is entered in that, then the matter ends.
See, clarifying a point of fact is another thing. You can't argue the case just like that. You have to wait for your turn. Otherwise, I'll get confused. किसका हम register करेंगे argument?
नहीं, why last time therefore I had objected. Your Lordship would recollect on the first date. Your Lordship asked them to argue. They said no, it is because appellant's appeal. I'll argue it subsequently.
No, I want it. Because your Lordship asked some certain clarification, then only I.
So you must
Otherwise, there is
confine
no
only to clarification.
Where is the finding something like that?
So, Your Lordship, whatever is said, one thing is absolutely whatever undisputed fact in the statement, plaintiff's case itself is that Harma Murmu's daughter was Juba. Whether she would inherit or not is the only question. Now, if she inherits, then there is no question of reversion. Once it is held that she inherits, now we are being a party, being a defendant, a party is entitled to take alternative plea. Because I am admittedly in possession of the properties have been recorded in my name. So if they are recorded and the plaintiff files a suit claiming his right that my ancestor, that means Juba, did not have any right to inherit her father's property, then they have to show. I had taken a plea that even otherwise as a daughter she had a right to inherit.
What else do you want to read?
Yes. Your Lordship may only allow me to read further in next page, para 13.
Para 13.
Or from the previous paragraph itself, top of page 13. It is relevant to note here that another settled customary law of Santal noted in such Ganjar report is that even in the event of sonless, Santal died without son living behind a daughter without marriage, then the agnates with their consent may put such daughter in Ardhamite form of marriage and allow her to inherit the property of recorded tenant. However, if such daughter or sonless Santal solemnized ordinary form of marriage, then she is not entitled to inherit, and in such case, the property of sonless father must devolve to his nearest agnate and kindred. And if nearest agnate and kindred are also not available, then the property goes to village community. In the background of above authority of Narayan Soren, our Honorable High Court and customary law of Samraj, and in going through the impugned judgment, I find that the trial court neither appreciated such customary law nor properly discussed the documentary evidence and material on record in accordance with the customary law of inheritance by Santal daughter Joba Murmu, and completely misguided his finding towards the wrong angle as per general law of inheritance by Hindu, with observation that there is change in Santal customary. The learned trial court failed to appreciate his own orders by which he allowed amendment of the claim by introducing para 14 and 14b in the claim, as well as orders by which Exhibit 1 document has been called for from the record of the present settlement authorities, Dumka, and also failed to consider the import of the order dated so and so, passed by Honorable High Court, by which the order of rejection of deposition of one witnesses passed by the trial court has been set aside with certain directions in such order reported in so and so. So here I'll pause here. The trial court's finding is being set aside by the appellate court on the ground that there was a interlocutory order passed by the trial court in which some observations were made and in which the amendment was allowed. Therefore, the reasons assigned in that order allowing amendment ought to have been considered by the trial. This is absolutely erroneous. The learned trial court discussed and observed that in the case of Himasya versus so and so, it is not helpful, by which our apex court have been pleased to observe that custom is authoritative, it stands the place of law and regulates the conduct of men in most important concerns of life. Passion is arbitrary and capricious, it decides the matter of tripling in court, manner and so and so. And however, the learned trial court held that such authority of law is not helpful for the plaintiff in adopting general law for deciding the controversy, travelled in the wrong direction and failed to consider that the Santhal customary law is authoritative and it stands as a force of law for guiding Santhal community. In such background, the admitted custom of the parties to this suit certainly takes place and gives overriding effect on general law. The defendant have tried to impress upon this court the right of inheritance by female daughters taking change, and a Ghar Jamai can inherit both the properties of his natural father and his father-in-law, but the defendants have failed to place any cogent evidence to establish such change of customary law. Now, this paragraph your Lordship may kindly take. Why I say? Because he has earlier observed that we had given up that portion where we had only confined ourselves to Ghar Jamai, claim through Ghar Jamai. Here he is taking note that we have clearly said that the defendants tried to impress upon this court that the right of inheritance by female daughters taking change, and a Ghar Jamai can inherit both properties of its so and so and his father-in-law, but the defendant failed to place any cogent evidence to establish such change of customary law. Here his finding is absolutely wrong, because Ganger's report itself had taken note of that change in customary.
And he also takes note of the fact your alternative plea has been taken note of.
Yes, yes.
But there he confines it to only Ghar
Only
Jamai,
one portion.
and the entire discussion is on Ghar Jamai form of marriage.
Yes.
And subsequently he takes note of your alternative plea by saying this.
Yes.
So at that stage he has confined, discussed Ghar Jamai, rejected your plea on Ghar Jamai form of marriage.
Yes.
And further here he starts discussing your alternative
That
plea.
there is a
And saying
change
that
in
there
law.
is no evidence that there is a change.
Yes. But the portion on which report which he is relying, that itself says that there is change. Not a single instance has been brought on record to effect that any ordinary married Santhal daughter and her Ghar Jamai husband inherited both the property. I agree with the submission that change in custom can be accepted, but such change must be proved by cogent change circumstances of the prevailing custom. Very clear and contradictory to the actual report on which he is relying. In stopping this discussion for a little later, now I find it essential to keep aside the findings of the trial court and independently travel and discuss the pleadings, oral and documentary evidences of rival parties independently in the context of customary law and dispute involved in this case. In the plain reading of the above noted customary law of Santhal community, I find that in order to establish the right of inheritance by Santhal daughter by virtue of Ghar Jamai marriage, there are certain customary conditions required to be fulfilled and established. The first precondition is that Santhal father must not have any son, but having daughters only. In this case, it is admitted case that the recorded tenant Harma Murmu, father of Joba Murmu, died without a son. Thus, first requisite is available. The second precondition is that Santhal daughter was put in Ghar Jamai form of marriage by her sonless Santhal father. On this point, there appears no direct evidence. Neither PWs nor DWs would be able to depose nor any documentary evidence available to show that the recorded Santhal tenant Jharkhand Murmu had put his daughter Joba Murmu in Ghar Jamai form of marriage with Kanu Murmu. The trial court observed in para so that on going through the pleading, evidences and argument of both sides, it is apparent that none of the parties have brought on record about clear-cut date or year of death of Harma Murmu, nor they brought the year of and date of death of even approximate of marriage of Joba Murmu, nor any witness who may say that he had seen the marriage of Joba Murmu. So finding regarding ordinary and Gharjamai marriage will be concluded on the basis of happenings, circumstances, and acts acted upon. The plaintiff had pleaded that Harma Murmu died some year past in Ganjar settlement, whereas the defendant pleaded that she died about 5 years. He died about 5 years after the Ganjar settlement. Likewise, no paper has been brought on record which make clear that the ticket was the son of Karu Murmu. So, finding about admit will be concluded on the basis of analysis and circumstances suggested through documentary and oral evidence. This court agrees with such observation made by learned trial court that there is no direct evidence either on the point of ordinary or Gharjamai marriage between Joba Murmu and Kanu Murmu and Kanuanda, and similarly there is no direct evidence regarding relation between Harma Murmu and Tikat Murmu, and such fact can only be ascertained by relevant documentary and hearsay oral evidence of the witnesses of rival parties. However, at this stage I confine myself on the above second precondition that there is no evidence to establish that recorded tenant Harma Murmu had put her daughter Joba Murmu in Gharjamai form of marriage, and it is quite natural because the document which will be discussed little later on show that their marriage was solemnized about 50 before Ganjar settlement on an unknown date about 80 to 90 years or maybe 100 years ago. So here he does not discuss as to whether it was in Gharjamai or not, and here he could not have set aside the finding of the trial court who says that because there is no other document, therefore inference would be that because she and her daughters, sons, they were residing and found to be in possession of the same property, her son also and grandson also, therefore it could be assumed that her marriage was in Jharkhand. This finding cannot be set aside by an appellate court unless this finding was found to be pertinent. The third and the most precondition for accepting a Gharjamai is that a sonless Santhal father, after putting his daughter in Gharjamai form of marriage, must keep his Gharjamai son-in-law in his own house, just like an adopted son, and the Gharjamai son-in-law, after the induction of Gharjamai, must cut off all his relation with his own natural family as far as his right to inherit the property are concerned, and become all intent and purposes the son of his father-in-law. That there is fourth and another vital rule of some custom in Santhal community is that final report of so and so referred to by High Court in Narayan Soren, that it is set forth Santhal customary law that any partition, inheritance and marriage should be dealt with more fully in the settlement record of right of Santhal villages. In satisfying these requirements, only a Gharjamai son-in-law can succeed just like an adopted son of his father-in-law and oust any other male relative or ragnate from inheritance of the property of his father-in-law and become entitled to inherit his property jointly with his wife, and fulfillment of these conditions only a Santhal daughter or descendant son, grandsons and other grandsons of such daughter and Gharjamai son-in-law can inherit the property of such sonless recorded Santhal tenant. In search of evidence on those third and fourth important conditions, I find it essential to make a note of some admitted and established fact appeared in pleadings and evidences of both the parties.
We shall continue day after.
Dear.
Next one, look at Jharkhand. Second appeal number 309 of 2016. Heard the learned counsel pleading on behalf of the appellant. Appellants, the learned counsel for the respondents is also present. The learned counsel appearing on behalf of the appellant has submitted that on going through the judgment passed by the first appellate court, the substantial question of law as framed by order dated 1/11/2018 may not fall for consideration. However, primarily he has advanced his argument with regard to the substantial question of law framed by the order dated 6th of May 2025. At the request of the counsel for the parties, the matter is edited to be posted for further hearing on the applicant. वो वाला आप उनको ना पूरा एक फोटो कॉपी या कैसे भी उसको ऊपर करके दीजिए, वो सेटलमेंट वो जो दे रहे थे ना उसको आपको मिला है वो, you have seen that? आपने देखा है? या आपके पास किताब नहीं
ये
है?
सर लाइब्रेरी
हम नहीं करा देते
इसमें से देखिए
सेम चीज
फ्लैग करा
एक खाली फोटो कॉपी करके देंगे।
हम
परसों के लिए कुछ रखे हैं क्या हम लोग? नहीं रखे हैं ना? When do you want to do day after tomorrow? What time? Any time you want? We can
if
start
2:15 it would be better.
at 2:15.